announcing our clerk. Let's see if we can round up Ms. Lewis.
Recording in progress.
While we're waiting for Ms. Lewis, we have provided counsel a copy of the initial charge that I intend to present to the jury. And I had requested that both sides take a look at it and make sure that there wasn't any issue with it. I have received a request for a jury charge from the defense counsel. And Mr. Lockhart, I have reviewed that. It appears to me that your request is based on the Bishop standard that you're asking me to charge the jury with what is essentially the law that I must consider in determining whether or not there is sufficient corroboration of this confession in order to allow it to be admitted as evidence. We've dealt with this in a number of pretrial hearings, and in my opinion, your request is that I charge the jury with the law that I must apply, and therefore I am declining to include in my initial charge to the jury your request. In the final charge, as we all know, the initial charge to the jury is not something absolutely required by the law or procedure. It is intended to help the jury understand their role and how this trial will proceed. It is not the ultimate repository of all of the definitions and the legal standards that will be in the final charge. So we can consider any additional charges you wish to make or instructions you wish to make in the final charge, but for the initial charge, I am declining to grant your request for the language that you had requested.
Your Honor, I would request that what I submitted be filed for the purpose of the record. And
there's a two-page document at the top of the first page that states jury charge requested by the defendant. It then sets forth the language from the State versus Bishop, which is basically talking about the admission of a confession and what is required under the modified trustworthiness standard. The jury does not apply the modified trustworthiness standard, the court does, and that's the reason I'm declining it.
but the court's still leaving it open for the final charge because Tennessee criminal trial practice makes clear that is the standard the jury will have to find in regard to the trustworthiness and in regard to the corpus delicti. So it's still open for me to ask.
You can, as I stated, you can request for any additional challenges you wish, or rather charges you wish to make at the final charge, but for the initial charge, I am not granting a request. I'll mark it as an exhibit, or mark it a part of the file rather, and we'll go from there.
Yes, Your Honor.
Having said that, we are ready to bring the jury in. The first charge will be the initial charge. We're styling it the third initial charge of the court because those of you who were with us in Chattanooga are aware that the first charge I gave them was as they were discharged to go home and pack for 2 weeks to come back to the bus. The second charge, I placed them under oath and requested that they affirm that they had not violated my order regarding investigating or trying to obtain information about this case. They all affirmed under oath that they had not violated my instructions. I then had them sworn as the jury, and following that swearing in of the jury, I gave them a brief second initial charge, if you want to call it that, that was designed to help them understand what a sequestered jury entails and what their situation would be as far as their obligations and duties and responsibilities. So this will actually be the instructions as to the trial procedures and the law on the front end that we'll be giving them. They've already had 2 others. All right, we're ready for the jury. Then anything before we bring the jury in? And for the record, I brought the jury in the absence. We cleared the courtroom. I brought the jury in and had them examine the jury box. We had set up additional chairs and marked chairs in between. They were unanimous in their desire to sit in the seats that were designated. They believe those seats, and they are 3 feet between the back of the front row and the back row, And they have been sitting side by side throughout this process, so they voted unanimously to be able to sit in those seats rather than to have any other distance between them. So we're going to bring the jury in unless there's something else.
Just want to announce, we've agreed to waive the rule as to my client's parents, Agent Joe Craig, and investigator Christy Tillingsworth. That's correct.
All right, we'll show that that rule has been waived as to those individuals. I assume the rule has been requested as to all others.
Yes, Your Honor.
All right. Then we'll bring the jury in. Thank you. Let me give you this. If you'll just hand a copy, this is a copy of the charge I'm about to read it in. If you'll hand them one as they come in, please. Short one. All right, ladies and gentlemen, you can have a seat. Thank you. Gentlemen, you're going to have to be a little quicker if you're going to get those back row seats like you wanted, so you're going to have to move quickly out of that door. Ladies and gentlemen, this is the process by which the point in time where I will read to you what would normally be the initial charge of the court, but since I've already given you, as you know, 2 other charges while we were in Chattanooga, this will be what I term the 3rd initial charge of the court. If you'll read along with me, we'll proceed. Ladies and gentlemen of the jury, the defendant, Joseph Ray Daniels, is charged in count 1 of the indictment with the crime of first-degree murder. In count 2 of the indictment, the defendant is charged with first-degree murder in perpetration of a felony. In count 3 in the indictment, the defendant is charged with aggravated child abuse. In count 4 in the indictment, the defendant is charged with initiating a false report. In count 5 in the indictment, the defendant is charged with tampering with evidence. The defendant pleads not guilty to all of the offenses embraced in the indictment. Before we begin the trial, I would like to tell you a little bit about what will happen during the course of the proceedings. I want to describe basically how the trial will be conducted and what the attorneys, jurors, and judge will be doing over the course of the trial. At the end of the trial, I will give you more detailed instructions on how you're to go about reaching your decision. But now I simply want to explain how the trial will proceed. The law applicable to this case is stated in these instructions and those that follow, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. The defendant has been charged by the state of Tennessee with a violation of state law. The document containing the charges is referred to as an indictment. An indictment is a formal accusation charging a defendant with a crime and is not evidence of anything. The defendant is charged in count 1 in the indictment with first-degree murder. For you to find the defendant guilty, the state must have proven beyond a reasonable doubt that the defendant unlawfully killed the alleged victim, Joe Clyde Daniels, that the defendant acted intentionally, and that the killing was premeditated. The defendant is charged in count 2 in the indictment with first-degree murder in perpetration of a felony. For you to find the defendant guilty, the state must have proven beyond a reasonable doubt that the defendant unlawfully killed the alleged victim, Joe Clyde Daniels, that the killing was committed in the perpetration of or the attempt to perpetrate aggravated child abuse, that the killing was closely connected to the alleged aggravated child abuse and was not a separate, distinct, and independent event, and the defendant intended to commit the alleged aggravated child abuse. The defendant is charged in count 3 in the indictment with aggravated child abuse. For you to find the defendant guilty, the state must have proven beyond a reasonable doubt that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury, and that the act of abuse resulted in serious bodily injury to the child. The defendant is charged in count 4 in the indictment with initiating a false report or statement to law enforcement officer. For you to find the defendant guilty, the state must have proven beyond a reasonable doubt that the defendant initiated a report or statement to a law enforcement officer concerning an offense or incident, that the defendant knew the information relating to the offense reported was false, and that the defendant knew the offense or incident reported did not occur. The defendant is charged in count 5 in the indictment with tampering with evidence. For you to find the defendant guilty, the state must have proven beyond a reasonable doubt that the defendant knew an investigation or official proceeding was in progress, that the defendant destroyed or concealed evidence with the intent to impair its availability as evidence in the investigation or official proceeding. The defendant has pled not guilty to the charges in the indictment. He is presumed innocent and may not be found guilty by you unless, after hearing all of the evidence, attorneys' arguments, and instructions of law, the 12 jurors seated in this case unanimously find that the state has proven its case beyond a reasonable doubt. The first step in the trial will be the attorney's opening statements. The state will tell you about the evidence it intends to present so that you will have an idea what the state's case is about. This opening statement is not evidence. Its only purpose is to help you understand what the evidence will be and what the state will attempt to prove. After the state's opening statement, an attorney for the defendant may make an opening statement if they so choose. Again, statements of attorneys are not evidence. Next will be the state's case in chief, in which the state will present its evidence. The evidence in the case will most likely consist of physical exhibits, documents, and the testimony of witnesses. The witnesses will testify by answering questions asked by the attorneys. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Dickson County, Tennessee, then you must return a verdict of not guilty. After the state completes its case in chief, the defense will be given an opportunity to present evidence through witnesses and exhibits. A defendant is not required to put on any evidence or to testify. The burden is always on the state to convince you that the defendant is guilty beyond a reasonable doubt. If the defense does present proof, the state may then put on what is known as rebuttal proof. After the state's rebuttal, the defense may put on further proof. After you have heard all of the evidence, the state and the defense may present final arguments. I previously told you that opening statements by the attorneys are not evidence. Likewise, closing arguments are not evidence. In closing arguments, the parties will attempt to summarize their cases and to help you understand the evidence that was presented. The final part of the trial occurs when I instruct you about the rules of law that you are to use in reaching your verdict. After you hear my instructions, the final 12 jurors will leave the courtroom together as a group. You will then begin your deliberations to make a decision in the case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. Now that I have described in outline form the trial itself, let me explain the functions that you and I will perform during the trial. I will decide which rules of law apply to the case. My decisions will be reflected in my responses to questions and objections the attorneys raised during the trial, as well as in my final jury instructions. It is your job to determine what the facts are from the evidence. You must then apply the law and my instructions to the facts, and from that application you will arrive at a verdict. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the entire case. Keep in mind that the defendant is presumed to be innocent of the charges against him. Thus, the defendant is not required to prove his innocence, to have his attorney make any statements or arguments, or to produce any evidence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case, and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required. And this certainty is required as to every element of proof necessary to constitute the offense. You, as jurors, must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crime charged in the indictment. You must base that decision only on the evidence in the case and my instructions about the law. Witnesses will testify in response to questions from the attorneys. Witnesses are first asked questions by the party who calls the witness to testify, and then the other side is permitted to cross-examine the witnesses. Although evidence is presented by asking questions, the questions themselves are not evidence. An insinuation contained in a question is not evidence. You should consider a question only as it gives meaning to the witness's answer. In addition, members of the jury may ask questions of the witness if desired. The procedure for a juror to ask a question of the witness is that the question must be written down and submitted to me. Do not put your name on the question, as the questions for the jury are required to be anonymous. If a juror has a question that he or she would like to have asked of a witness, that question must be submitted in writing while the witness remains on the witness stand. At the end of the witness's testimony, the jury will be excused and I will consider the questions of the jury on the record. Then the jury will return to the courtroom. If the question is allowed by the rules of evidence, the question will be asked either by me or by one of the lawyers. You should not place any significance upon the fact that I asked the question of the witness or whether one of the lawyers asked the question. In either event, the question is being asked of the witness solely because it was desired by a juror. The wording of the question may be altered by me, or the question may not be asked at all. If the question is altered by me, you must assume that I had a valid legal reason for altering it, and you should place no significance upon this fact, nor should you draw any inference from it. I may refuse to ask the question at all. In that case, you likewise should place no significance upon this fact, nor should you draw any inference from it. Many times our rules of evidence do not allow certain questions to be asked, even if both sides desire to do so. After the trial, if you wish to know the answer to your question or the reason it could not be asked, please approach the bench after court is adjourned and I will attempt to explain it to you. An important part of your job will be making judgments about the testimony of the witnesses who testify. You should decide whether you believe what each person says and the importance of his or her testimony. In making that decision, I suggest that you ask yourself a few questions. Did the person impress you as honest? Did he or she have a particular reason not to tell the truth? Did he or she have a personal interest in the outcome of the case? Did the witness have any motive, bias, or prejudice that would influence the witness's testimony? Did the witness seem to have a memory of the events he or she testified about? Did the witness have the opportunity and ability to observe accurately the things he or she testified about? Did he or she appear to understand the questions clearly and answer them directly? Was the witness distracted in any way? How did the witness look and act while testifying? Was the witness making an honest effort to tell the truth, or did the witness evade questions? Did a witness's testimony differ from the testimony of other witnesses? Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. As the sole judges of the facts, you must determine which of the witness's testimony you accept, what weight you attach to it, and what inferences you will draw from it. The law does not, however, require you to accept all of the evidence. In deciding what evidence you will accept, you must make your own evaluation of the testimony given by each of the witnesses and determine the weight you will give to that testimony. You must decide which witnesses you believe and how important you think their testimony is. You're not required to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding what testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules to use in deciding whether you believe a witness. In making up your mind and reaching a verdict, do not base any decisions on the fact that there are more witnesses on one side than on the other. Likewise, do not reach a conclusion on a particular point just because more witnesses testified for one side on that point. Your job is to think about the testimony of each witness you heard and decide the facts. At times during the trial, an attorney may make an objection to a question that is asked by another attorney or to an answer that a witness gives. This simply means that the attorney is requesting that I make a decision on a particular rule of law. Do not draw any conclusions from the fact that an objection was made or from my ruling on that objection. My rulings only relate to the legal questions that I must determine and should not influence your thinking. If I sustain an objection to a question, the witness will not be permitted to answer the question. Do not attempt to guess what the answer might have been had the witness been permitted to give it. Similarly, if I tell you not to consider a particular statement that was made, you should put that statement out of your mind, and you may not refer to that statement in your later deliberations. In deciding this case, you may not draw any inference from an unanswered question, and you may not consider testimony that you're instructed to disregard. Any arguments about objections or motions are usually required to be made by the attorneys out of the hearing of the jury. Information may be excluded because it is not legally admissible. Excluded information cannot be considered in reaching your decision. A ruling that is made on an objection or motion will be based solely upon the law. You must not infer from a ruling that I hold any view or opinion for or against any party in this lawsuit. Some of you have probably heard the terms circumstantial evidence and direct evidence. These are the two basic types of evidence that exist in the law. Direct evidence is direct proof of a fact, such as the testimony of an eyewitness. Direct evidence is those parts of the testimony admitted in court which referred to what happened and was testified to by witnesses who saw, heard, or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw, heard, or otherwise sensed, they presented direct evidence. Circumstantial evidence is all of the testimony exhibits which give you clues about what happened in an indirect way. It consists of all of the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. The court will not provide you with a transcript of the testimony at the end of the trial. Therefore, you must listen very carefully to the testimony. Each of you will be allowed to take notes during the trial for your own use during your deliberations. You are not required to take notes. Independent memory can be as accurate as written notes. You will be provided with a paper and pen if you decide to take notes. During the course of the trial, you should not talk with any witness, defendant, or attorney involved in this case. Please do not talk with them about any subject whatsoever. You may see them in a hallway or on an elevator at some other location. If you do, perhaps the best standing rule is not to say anything. Do not permit any other person to discuss this case in your presence. If anyone does attempt to do so, report this fact to the court immediately without discussing the incident with any of the other jurors. You also should not discuss this case among yourselves until I instruct you on the law and you start deliberating at the end of the case. It is important that you wait until all of the evidence is received and you have heard all of my instructions on the rules of law before you deliberate among yourselves. You must not communicate with or provide any information, photographs, or video to anyone by any means about this case. You must not use any electronic device or media such as a telephone, cell phone, smartphone, or computer, the internet, any text or instant messaging service, or any chat room, blog, or websites such as Facebook, MySpace, LinkedIn, YouTube, Instagram, Snapchat, or Twitter, to communicate with anyone or to conduct any research about this case. During the course of the trial, there's a possibility, in this case more than a possibility, that there will be media reports in the newspapers, on TV, or on the radio about this particular case. If there are, you are not permitted to read, watch, or listen to those reports. You as the jurors must base your decision solely on the evidence you hear in the courtroom. You will receive all of the evidence you may properly consider to decide the case. Because of this, you should not attempt to do any research on your own or gather any information on your own that you think might be helpful. Do not conduct your own private investigation into this case, although you may be tempted to do so. Do not read any textbooks or articles concerning any issue in this case, or consult any other source of information. If you were to do that, you would be getting information that is not evidence. You must decide this case only on the evidence and law presented to you during the trial. Any juror who receives any information about this case other than that presented at trial must notify the court immediately. There are several rules concerning your conduct during the trial and during recesses that you should keep in mind. You will be a sequestered jury. You will not be allowed to communicate with anyone other than your fellow jurors and your sworn jury guards during the entire time that you serve on this jury. You will be kept together as a jury and separated from everyone else. You must not be outside of the presence of the supervision of your jury guards at any time other than when in your room. You must not speak to anyone other than your fellow jurors or guards at any time about any subject whatsoever. Second, do not discuss this case among yourselves during the trial. You must keep an open mind until you have heard all of the evidence, the attorney's closing arguments, and my final instructions concerning the law. Any discussions before the conclusion of the case would be premature and improper. Third, obey all instructions from your jury guards. They have been thoroughly instructed as to the proper procedure that must be followed. If they ask you to do something, there is a reason for it. Finally, during the course of the trial, I may have to interrupt the proceedings to confer with the attorneys about the rules of law that should apply. In some cases, we may have bench conferences in the courtroom outside of your hearing. And in some instances, I may ask you to retire to the jury room while we discuss the matter out of your presence. I will try to avoid as many of these interruptions as possible. We will try to resolve some of these things in the morning before we get started. I ask your patience because these interruptions are necessary points in the trial where we have to resolve legal issues. In the long run, they save time for all of us. If anyone needs a break at any time, please do not hesitate to ask. Simply raise your hand. If I do not see you, get the attention of one of your bailiffs who will advise me that a juror needs a break. Normally, I will try to conclude the testimony of a witness before taking a break. The usual break times are at 10:30 in the morning and 2:30 in the afternoon, with a normal hour between 12 and 1 for lunch. If you need a break at any other time, please ask. A juror who is distracted is not paying full attention to the testimony. Both parties are entitled to your full, undivided attention to the case. This completes my opening comments to you. The next phase of the trial is the formal reading to you of the indictment in this case. This is the third day of June 2020, David Wolf, Circuit Judge, Division 1. Mr. Crouch.
The grand jurors of Dixon County, Tennessee, duly impaneled and sworn upon their oaths present that on or about April the 4th of 2018 in Dixon County, Tennessee, and prior to the finding of this indictment, Joseph Ray Daniels then and there did unlawfully, intentionally, and with premeditation kill Joe Clyde Daniels in violation of TCA 3913-202. Count 2, the grand jurors of Dixon County, Tennessee, duly impaneled and sworn upon their oaths present that on or about April 4th, 2018 in Dixon County, Tennessee, and upon prior finding of this presentment, Joseph Ray Daniels then and there did unlawfully kill Joe Clyde Daniels in the perpetration or attempt to perpetrate aggravated child abuse in violation of TCA 3913-202. Count 3, the grand jurors of Dixon County, Tennessee, duly impaneled and sworn upon their oaths present that on or about April the 4th of 2018 in Dixon County, Tennessee, and prior to the finding of this presentment, Joseph Ray Daniels then and there did unlawfully and knowingly, other than by accidental means, treat Joe Clyde Daniels, a child under the age of 8, in such a manner as to inflict injury, and the act of abuse resulted in serious bodily injury to Joe Clyde Daniels in violation of Tennessee Code Annotated 3915-402. Count 4, the grand jurors of Dixon County, Tennessee, duly impaneled and sworn upon their oaths present that on or about April 4th, 2018, in Dixon County, Tennessee, and prior to the finding of this presentment, Joseph Ray Daniels then and there did unlawfully initiate a report or statement to law enforcement officers, to wit, a 911 call center concerning an offense or incident that the offense or incident reported did not occur, and information relating to the offense reported is false in violation of TCA 3916-502. Count 5, the grand jurors of Dixon County, Tennessee, duly impaneled and sworn upon their oaths present that on or about April the 4th, 2018 in Dixon County, Tennessee, and upon and prior to the finding of the presentment, Joseph Ray Daniels then and there did unlawfully and knowing that an investigation or official proceeding is in progress did destroy or conceal evidence with intent to impair its availability as evidence in the investigation or official proceeding in violation of TCA 3916-503.
To that indictment, has the defendant plead?
Not guilty.
All right, not guilty, has been, plea has been entered. At this point, ladies and gentlemen, it would be appropriate for either side to make an opening statement if they wish. The state would go first. The state would make an opening statement.
Yes.
All right, you may address the jury.
Ladies and gentlemen, welcome to Dickson County. Thank you for being here and thank you for your attention. I want to again introduce quickly the folks that are sitting at the state's table. To my left is Assistant DA Josh Turnbow, TBI Investigator Zach Burkhart, TBI Special Agent Joe Craig, and behind me, Criminal Investigator Josh Etheridge, who will be helping present some of our electrical and digital components. Joe Clyde Daniels. You're going to hear that name a lot. April 4th of 2018, Joe Clyde Daniels was 5 years old. You're going to see a video, probably the last video of Joe Clyde Daniels alive, from April the 3rd of 2018, when he gets off the school bus at the end of the day. He exits with his older brother Alex, who was 8 years old at the time. They get off the school bus. Their Aunt Joyce is waiting to greet them at the end of the driveway. And that's the last time we have evidence of him being alive on photograph or video. You're going to see proof that Joe Clyde was an active young boy. He loved going to school. He went to school at Centennial Elementary in Dickson. Joe Clyde loved his cowboy boots and he loved his plaid button-up shirts, and you're going to see those. Joe Clyde loved playing with his friends at schools, and he loved the one-on-one interaction from his school teachers. You're going to hear evidence that Joe Clyde loved to eat apples. And that sounds weird right now, but you'll understand as the trial goes along. You're going to hear that Joe Clyde did not like certain things, specifically loud noises, thunder. Those loud noises, chaos, they scared him. You're going to hear from Joe Clyde's teacher. You're going to hear from his speech pathologist that he was a great kid, that he was not difficult, he was not frustrating, and he didn't display very many negative behaviors at all. You're going to hear different stories as to the levels and abilities and disabilities of Joe Clyde. You're going to hear him referred to as having autism. You're going to hear the phrase global developmental disabilities. Essentially, you're going to hear that Joe Clyde Daniels had some learning delays. He was developmentally delayed. But Joe Clyde was able to communicate. He communicated by looking at you with eye contact, by pointing, by making gestures. And he was developing a better vocabulary. You're going to also hear evidence that Joe Clyde was very much lacking in his gross and fine motor skills. In fact, Joe Clyde ranked in the first percentile of classmates his age, the first percentile in gross motor skills. He had weak intrinsic hand muscles. He had problems separating and isolating and using his fingers. He had a hard time pulling out pegs, flipping pegs, opening items. He had a hard time using zippers, buttoning his shirt. He couldn't tie his shoes. At the time Joe Clyde was murdered, he lived in a household with 8 people. His brother Alex, as I've already referred to, who was 8 years old at the time. His brother Noah, who was 3 years old. His mother, Crystal Daniels, who, as you know, is also a defendant charged, but her trial is separate. This is not the trial of Crystal Daniels, but of Joseph Daniels. The defendant, who was married to Crystal Daniels, also lived in this residence. And this is where you have to be careful not to get the names confused. Joseph Daniels Jr., or Big Joe, grandpa, was Joe Clyde Daniels' grandfather. So in the house you had 3 Joes: grandfather, father, which is the defendant, and Joe Clyde Daniels, 5 years old. Also in the residence was Belle Daniels, who was married to Big Joe, the grandfather, and the aunt Joyce Austin. All 8 of these folks lived in a residence at 1222 Corners Creek Road in Dixon County. Just for some brief context as to the residence, Big Joe, the defendant's father, was the only person that was currently employed. And you will see that he was an over-the-road truck driver that did a long-haul drive from Tennessee to Texas and back. Belle Daniels, Big Joe's wife, was unemployed. Aunt Joyce was unemployed, and you're going to see that she has some hearing and speech difficulties as well. Crystal Daniels, the mother of Joe Clyde, unemployed. You're going to see that the defendant had quit his job in February of 2018 and was also unemployed. For some more background about the defendant and evidence that the state intends to prove at trial, he graduated, the defendant did, from Dixon County High School. He went on to attend college. He majored in computer information technology, and he earned a microcomputer specialist degree from Tennessee College of Applied Technology in 2012. At Nashville State Community College, he majored in computer sciences and computer networking technology. The defendant had recently held several jobs, his most recent being at a company here locally in Dixon called Logical LLC. He was a computer engineer and technician. The defendant has authored at least one sci-fi novel, a fiction work, that was found on his computer after executing a search warrant. This is not a dumb person. The defendant, you will see, has many faces. You're going to hear evidence of infidelity between the defendant and his wife. The co-defendant, Crystal Daniels, was cheating on him. You will see that on the night of April 3rd, the defendant and Crystal Daniels were in an argument over infidelity. You're going to hear evidence that Crystal Daniels was planning on leaving Joseph Daniels. You will even hear evidence that the defendant didn't think that Joe Clyde Daniels was his biological son. And you're going to see from a computer extraction evidence that he was searching on how to conduct paternity testing. You're going to hear evidence that the defendant referred to his deceased son as that boy. You're going to see evidence that the defendant had trouble controlling his temper. You're going to hear evidence likely that he had some mental health issues, although these are not an excuse for his actions. You will hear evidence that the defendant, during some of his evaluation, showed tendencies to malinger. Now, for those of you that don't know what malingering or malinger is, it's the intentional production of false or grossly exaggerated physical or psychological symptoms, motivated by external incentives such as avoiding military duty, avoiding work, obtaining financial compensation, evading criminal prosecution, or obtaining drugs. That's what malingering is. Now, on the night of April 3rd, 2018, it's important to note that their grandfather, Big Joe, and Belle were out of the state. They were on a long drive in his routine drive to Texas. Now, it's a round-trip drive, but they go to Texas and back. They were out of the state of Tennessee. In the residence on the night of April 3rd, 3 adults, Joseph Daniels, Crystal Daniels, and Joyce Austin, the aunt. 3 children, Alex, Noah, and Joe Clyde. On this particular evening, Noah was sleeping in a bedroom alone with Aunt Joyce. You're going to see that Alex and Joe Clyde Daniels were sleeping in the master bedroom that would normally be occupied by Big Joe and Belle. But since they were out of town, Alex and Joe Clyde slept in that room. The defendant and his wife Crystal were sleeping in their own bedroom. You will also hear and see proof that on this night it was raining outside with thunderstorms that were widely scattered across Middle Tennessee. You're going to hear a series of stories directly from the defendant. According to the defendant, on the night of April 3rd at about 11:30 p.m., Joe Clyde got out of bed, Remember, he's in Big Joe and Belle's bedroom and urinated in the floor. And apparently this was not uncommon behavior from Joe Clyde. Upon that occurring, the defendant got out of bed, and according to him, he puts Joe Clyde back into bed, and he himself returns back to bed, goes to sleep, and he doesn't wake up again until 5:30 a.m. And that's important to note, because that's the initial story that he gives. Joe Clyde urinates in the floor, he puts him back to bed, about 11:30 p.m., he sleeps until 5:30 a.m. The defendant then claims that he wakes up at 5:30 a.m., goes into the bedroom, and finds that Joe Clyde is gone. He says he searches the house, goes around outside, can't find him, and the search begins. At 6:22 a.m., so roughly 52 minutes after he notices Joe Clyde is missing from the house, he makes a 911 call. On this 911 call, which you will hear, the defendant claims that Joe Clyde escaped. He says, "My son has escaped and we cannot find him. He has autism. Last time he was seen was last night." How did he get out of the house? He was asked on the 911 call, and the defendant says he must have unlocked the door. He describes Joe Clyde as being roughly 48 inches tall and 65 pounds. He's asked how severe is his autism, and he says he has ADHD with it too, pretty significant. He can't talk, unable to communicate. He tries to bathe himself, but we have to bathe him. And you're going to hear this on the 911 call. The defendant's story then kind of progresses as first responders arrive on the scene. What he tells first responders, who are there quickly within 10 minutes of the 911 call, is that in the middle of the night, Joe Clyde goes into the living room and takes the coffee table and moves the coffee table to a door, climbs on top of the coffee table, gets a key off of the mantle over the fireplace, reaches to the top of the door where there's a padlock installed, sticks the key in the padlock, takes the padlock off the latch, returns the key to the top of the mantle, hides the padlock in some toys next to the door, gets off the table, pushes the table back to the center of the living room, exits the door, and closes the door behind him in the middle of a thunderstorm. That's his story to first responders. And ladies and gentlemen, from that story, law enforcement begins one of the largest searches in the history of Middle Tennessee for a missing child. Over 20 emergency services agencies responded to Garners Creek Road almost immediately. You're going to see photo evidence, video evidence, the volume of people that responded, not just emergency services, but citizen volunteers were literally bussed in on that day to do inch by inch, square by square, grid and GPS searches of the entire area. By 8 a.m., the Tennessee Highway Patrol had picked up the first responding deputy on the scene. His name was Sergeant Daniel Baker, and Sergeant Daniel Baker was in a helicopter by 8 a.m. over the area. By noon that day, the Tennessee Bureau of Investigation had dispatched its airplane with infrared cameras that was doing grid by grid searches over the entire Dickson County, Humphreys County area. Numerous canine search and rescue teams were deployed. Rescue divers, submersible cameras were brought in to search nearby ponds. Ponds were drained, completely emptied. The septic tank of the Daniels residence was drained. Hundreds of volunteers. All of these actions and searches took place based on the defendant's 911 call and his initial statements to first responders. Keep in mind, the defendant does give a confession, but it's 2.5 days later. For 2.5 days, based on these lies, the defendant and his wife are free to come and go wherever they want to go, to conceal, to destroy evidence. Free to go. They're not under investigation. They're not under scrutiny. They're not being held. They're free to come and go wherever they want. However, on April 6th, 2.5 days later, at approximately 4:00 p.m., The defendant and his wife voluntarily drove themselves down to the Dixon Police Department, not escorted by police, but voluntarily. Upon arrival, he was Mirandized, and you will see that on video. He was read his rights. He voluntarily engaged in an interview with law enforcement. And this leads to confession 1. And you're going to hear this confession and see it on video. And in it, the defendant states, and you're going to hear, that he admitted to his initial statements to law enforcement were a lie. They were a lie. He admits that he, the defendant, moved the coffee table, that he hid the padlock, that all the story was made up. What defendant says really happened on April the 4th was that he whipped Joe Clyde for urinating in the floor, and that after he whipped him, Joe Clyde got back out of bed and laughed at him. And so he whipped him some more. And then the defendant says that he whipped him again, and he was upset, so he put Joe Clyde outside of the house. And then you're going to hear the defendant say that Joe Clyde ran towards the road, Garners Creek Road. So the defendant goes outside, angry, gets Joe Clyde, brings him back inside, whips him some more, and then slams his body on top of a coffee table.
Your Honor, I request that item be
Ladies and gentlemen, you may step across the hallway while I take up the matter, please. All right, Mr. Lockhart. Mr. Mitchell.
Your Honor, in pretrial motions, the defense filed motions requesting that the state not be allowed to talk about the confession until they had put in evidence to corroborate the confession and make some form of prima facie showing of a crime. And the state's introducing that now after the court has ruled that that would have to wait until they'd had a hearing after putting forward evidence. We're asking that they not be allowed to talk about the confession until they put on evidence.
Let me hear from the state and their response.
Judge, first of all, as you have just instructed the jury, it's not evidence, it's opening statements. And second, there was never an order put down saying we couldn't discuss it in opening statements. The issue is admissibility of the confession to the jury after we put on corroborating evidence. Second, yesterday in voir dire, the defense spent a lengthy amount of time discussing false confessions. This jury's already aware that there was a confession. Let's not be blind. They just don't want me to talk about it. But I'm going to talk about it because that's not the law, unless Your Honor specifically instructs me to disregard any form of mention of the word confession. I'm going to keep going with it.
First of all, the court did not rule that there could not be some discussion. In fact, in response to Mr. Lockhart, one of his concerns was that if I did not make a definitive ruling on the issue of the admissibility of the confession, both as to voluntariness and trustworthiness, that he would be hamstrung in the jury selection and talking about the confession because it may or may not come in. The court advised at that time that the ruling on the trustworthiness under the modified trustworthiness standard under the Bishop case would be made after the state had put on sufficient corroborating evidence. I ruled that the confession itself would not be admitted until such time as we had had a Bishop hearing and that standard had been met in this court's opinion. Nowhere did I exclude either party from talking about the confession, and Mr. Crouch is right. Yesterday in Chattanooga during voir dire of the jury, a great deal of time was spent on, and in fact, Mr. Lockhart asked the jurors to raise their hand if they agreed that there could be a false confession. And they all unanimously raised their hand that they thought under circumstances there could be. So while the state is, in my opinion, entitled to make its opening statement regarding and talk about what they expect the case to show, like any other opening statement, the evidence may not bear out what the state is saying. The defense will also be able to talk about a false confession. I assume that would be something that you would address in your opening statement. However, in order to make sure the jury is reminded, when they return, I will instruct them once again that statements of counsel and opening statements are not evidence, and that they will have to wait until such testimony is admitted to them and consider only that testimony that is admitted by the court.
Thank you, Judge.
Your Honor, may we have a moment for Mr. Daniels to take his medication? Apparently he has some that he has to take at a certain time, and it's that time.
All right, well, let's do it while the jury's out. All right, Mr. Taylor, anything else before we bring the jury back?
No, Your Honor.
All right, both sides ready for the jury? All right, let's ask the jury to return, please. During the course of this trial, you're going to have many instances where you're going to get up to exercise your legs and walk across that hallway, so I apologize in advance for doing it. As I explained to you, sometimes I have to take up matters outside of your presence, and I did that. I just want to remind you that what I instructed you a moment ago, sometimes it's hard to remember that. What the lawyers, and we have two good lawyers, or I have many good lawyers on both sides of this case, and they're very accomplished orators, and they'll tell you things. You have to remember that what they say, and especially in opening statements, is not evidence. We haven't started the trial with witnesses yet. You decide the case on the witness's testimony and the exhibits that I allow in. And while the lawyers can make their argument, it is not evidence. Both lawyers may tell you what they think the proof is going to be. It may or may not turn out to be that when the trial is concluded. You may say, well, they didn't prove this or that, even though they said that. So that's up to the lawyers as what they think their case is going to involve and what they think is going to be admitted as evidence. Both sides have the right to state their position on that. But that statement by the lawyers is not evidence. So does everyone understand that? All right, with that admonition, then I'm going to allow Mr. Crouch to continue.
Let me make one clarification before we move on. When Judge Wolf refers to the good orator and good lawyer, he's talking about Assistant Josh Turnbow, not me. So, all right, back to the confession, the initial confession made by the defendant on April the 6th. First confession number one. The defendant admitted to police that Joe Clyde did not push the coffee table to the door and escape. He admits to police that he killed Joe Clyde. The defendant also says, when I get angry, things happen. And we're going to prove to you that night that he did get angry and things did happen. The murder of Joe Clyde Daniels. The defendant specifically tells investigators that he did not stop hitting Joe Clyde until he realized he had lost control. The defendant also tells investigators that Alex, age 8, saw everything. The defendant admits that he threatened to kill Alex should Alex disclose what he saw. The defendant describes to investigators exactly what he was wearing when he committed the murder. Red gym shorts, a black shirt with an alien wearing a Santa cap and the text, "I believe." It just so happens that in the destruction of some of the evidence, that shirt was washed and it was recovered by the TBI, as you will see, out of the laundry in the defendant's home. On the night of April 6th, the defendant agreed to take law enforcement to the location in which he had concealed Joe Clyde's body. You're going to see that that was a lie and that the defendant never intended to disclose the location or what exactly he did to Joe Clyde's body. In a car ride from the police department to McElhaney Road, which is near the defendant's residence, you're going to hear the defendant say, unsolicited, you're going to hear him say, "I want all the monies that have been donated from 2 days of searching, volunteers, donations being made. I want these monies donated to pay for Joe Clyde's funeral expenses." His body is not found that night. As you will see, it's never been found because the defendant has continued to conceal the location. The proof is going to show that the following morning on April the 7th, the defendant admits to law enforcement that he lied about the location of the body. He didn't lie about killing Joe Clyde, but lied about the location of where he concealed the body. He then signs, after being Mirandized, a written confession saying that he killed Joe Clyde. The defendant is then taken to jail, and later that day, after several hours, he initiates a phone call. Not law enforcement, but the defendant makes a phone call to law enforcement and says he wants to provide some additional details. And what he tells law enforcement is that he had discarded the body by placing it in the trunk of the car, that he had driven to a truck stop approximately 9 miles away from his house. He stopped at the truck stop. That Joe Clyde's body was in the trunk of the car. He went into Love's, bought something, and then took the body and threw it off of a bridge into some water. That's the third confession. They get the defendant out of the jail at his request and take him to multiple bridges to see if he can show them exactly which one. And he continues to lie. The defendant is then driven back over to the command center, which is still up and running, and it just so happens that Big Joe, the defendant's father, is back in town from his long-haul drive. TBI agent Brant Holt allows the defendant's father, Big Joe, to get in the vehicle with the defendant. And in the vehicle, the defendant tells his father, "I beat Joe Clyde." Not coerced. "I beat Joe Clyde." Tells his own father that. I want you to step aside from what I've just been talking about, as our proof will be of these confessions. And when the proof goes down starting this afternoon and throughout the rest of the time, please pay special attention to the defendant's movements away from the house beginning in the early morning hours of April 4th, 2018. What you're going to see when this search starts is that the initial responders go to the defendant's house and they try to take some initial questions from both parents. Demographic type questions, very specific questions to help them define these search grids. He leaves. You're going to see proof that the defendant, as the wife is being asked these questions, gets in his car and leaves. And he drives around the neighborhood, not once, not twice, 3 times. And you're going to see through GPS locations that the defendant, where does he drive? 9 miles away to Love's. And then back. And he returns to the house. And when he gets back to the house, he makes one request of law enforcement. Check my trunk. The trunk of his car. The proof is going to show that these confessions were voluntarily made, that they were not coerced in any way. In fact, the last 2 confessions came about from the defendant calling law enforcement, as far from coercion as you can possibly get. Yesterday I asked number 1 question for you to follow the law, and I'm asking that same question again of you today. You're from Hamilton County, this is Dickson County. I wore my Tennessee flag today because we're all citizens of the state of Tennessee under the same law. We carry the burden of proof in this trial. Hold us to that burden. Make us prove this case beyond a reasonable doubt. But when we conclude and you go to deliberate, do not reward the defendant for being successful at destroying evidence and concealing a body. Thank you.
Mr. Lockard?
Ladies and gentlemen, an opening statement is an opportunity for both sides to kind of lay out what they think the proof is going to show. It's kind of like a map that can help you as you go through this trial see where this case is going. And obviously, we disagree with the state on what we think the evidence is going to show. But you will hear testimony and proof that when our client, after he had contacted police, he told them that he had got up that morning, got Joe Clyde Daniels' clothing for school and Alex's clothing for school, laid them on the coffee table, and then went to see, to wake the boys up. When he got in there, Joe Clyde Daniels was not present. He drove around and looked some. He even took the brother Alex to drive around and look. He called his father and then called 911. And you will see that that's what Mr. Daniels told law enforcement when he came in to be questioned. He told them over and over again that's what happened. But law enforcement would not accept that answer. And they continued to accuse him of lying, that you've got to tell us what happened, what law enforcement wanted. The truth they wanted was for our client to say he did something to Joe Clyde. But 20-something times he tells them, I didn't do anything. They stay on him and stay on him in that questioning and tell him essentially, we're not going to stop until you tell us what we want to hear. And they go hours. And eventually, the TBI and law enforcement start giving him information that he can use to say he did something. So they tell him that they know someone left the house. They tell him that they know someone took Joe Clyde Daniels from the house. They start feeding him the information, and as you watch the confession, you can see him gradually start realizing, I'm going to have to tell them what they want to hear if this is going to be over. Keep in mind, my client's mentally ill. And so you can see in his face, he gradually starts realizing, and at first he thinks he's in trouble because they forgot to lock the door. And so he tells them that Joe Clyde scooted the coffee table over and took the lock off the latch. It's possible that he scooted the coffee table over. And we don't contend that he had the motor dexterity to unlock the lock. We do contend that he would have been able to take an unlocked lock off the latch and just lift it out. But you'll see that was not enough. So they stayed on him, and then he moved to saying, well, I took it off and I put him outside. And then I went out and got him, brought him back in, and I spanked him more. And at first he tells them he did pee in the floor, and I just told him to get back in bed. But that wasn't enough for law enforcement. They wanted something more. So TBI agent Joey Boyd, and he can explain to you why he said it, but he told him if it was him, he would have whooped their ass too. So he's telling him, say you was mad, say you whipped his ass, say you beat him. That's what Agent Boyd's trying to get him to say. And so they keep going, and he goes a little further and says, okay, yeah, I whipped him hard. And Agent Boyd will tell him how many times you hit him. Wasn't it more than a few, or wasn't it this? Yeah. And wouldn't you say that you were pissed off? Yeah. He says, yeah, I was pissed off. He just gradually adopts what they're telling him into his statement. They keep on him, and finally, Agent Boyd points to the door and says, "You tell us the truth," which means the truth they wanted, "you'll walk right out that door. You're going to leave here." And my mentally ill client believed, well, I'll just tell them what they want to hear. And then I get to leave. I get to walk out that door. So he did. He told them that he beat Joe Clyde Daniels 15 to 20 minutes in the living room on the coffee table. That he, our client, with a black belt in karate who weighed 282 pounds, beat him for 15 to 20 minutes, opened a wound on his head. Blood was running down both sides of his face. Blood was on his leg where he threw him into the coffee table. He starts giving the agents what they want. But still they're having trouble getting specifics out of him. And at one point, the TBI agent Faulkner asked him, are you remembering what's happening? Or are you making this up? I mean, you're not making this up, right? So even the TBI agent realizes that he's making stuff up. And ask him, you're not making this up, right? That agent was spot on right there. He was making it up. And not long after that, our client tells him, I don't really remember. I'm just speculating what may have happened. So they do get a confession. But I submit to you that it was a false confession. And not just because the agent doubted whether he was telling the truth, not just because the agent said, are you making this up? That's a great indicator that even the TBI thought he's making it up. But also because what he told them was not borne out by the evidence. You'll see that the forensic scientists went into the house. They cut up carpet to check for stains around the coffee table. They checked the coffee table. They searched the house thoroughly. They searched the vehicle, the trunk of the vehicle. And even though our client had confessed to beating this child 15 to 20 minutes, even though he said there was blood running down both sides of his face, even though all that was said, not one drop of Joe Clyde Daniels' blood was found anywhere in the house, not on the coffee table, not in the carpet. You'll see photos and a video where law enforcement arrived. There's been no forensic cleaning. You don't have areas in the carpet that have been bleached. There's simply no physical evidence that what our client told them is true. Same thing for the car. TBI investigation will then show that the car did not leave the house. Our client said that he killed Joe Clyde Daniels. He carried his unwrapped body out, put it in the trunk of the car, left and took the body off McElhaney Road, walked out in a field in shorts, using his wife's cell phone as a flashlight, then came back home and got in bed right around midnight. Other evidence is going to show you that didn't happen. The TBI, in their own search warrant, admitted that it was not believed that that vehicle left at that time. In fact, they used that in a search warrant because they believe there's probable cause that Joe Clyde Daniels' body is there in the yard at the residence. And so they acknowledge what he told them is not true. He didn't kill him, take him off at 11 or midnight, come back home, get in bed by midnight and go to sleep. That didn't happen. There's no blood evidence of that, no physical evidence of that. They know the car didn't leave because they saw the neighbor's security video, and they made oath in an affidavit for a search warrant that they don't believe the car left and that they think the body's probably in the yard. So they realize that the confession is false, and they're trying to find another way to get evidence against our client. So they bring in crews, and for almost 2 weeks, they've got machines that can sonar or x-ray or whatever, check the ground. They dig holes up. All they find in the yard are some dog bones. So Joe Clyde Daniels is not there. And they know they've got problems with the case because a witness by the name of Daniel McCormick, who was driving home from Belmont University in Nashville at approximately 12:45 in the morning, saw a person he described as a teenager or a smaller teenager or person. He describes this person he sees as wearing a black shirt with a skeleton on the front, either white or glow in the dark. That is exactly what Joe Clyde Daniels was wearing. And the significance of that is, if our client's confession is true, and he had killed this young man and taken the body off, then came back home and got in bed around midnight, then how is this child that he killed and concealed the body standing alive out there in the road? He's not. The state at first, and the TBI acknowledged in testimony, in statements, they acknowledged that that was Joe Clyde Daniels that was seen out there on the side of the road. But that started changing when they realized, put two and two together, and realized this child was a third of the mile down the road, which did not corroborate our client's statement. In his confession, he said that he ran out to the end of the driveway, brought Joe Clyde back. So it doesn't corroborate that. And if he's killed him and gotten rid of the body, how's he alive standing on the side of the road at 1:45 in the morning? He can't be. So the state kind of moves from adopting that Mr. McCormick saw the child, and I submit they'll try to convince you now that Mr. McCormick saw our client standing out there in the road. But Mr. McCormick will tell you it was not a grown adult. It was not a man that weighed 282 pounds, and he is certain as to what he saw. So all those things are things you'll look at that will tell you that the confession is not true. Not just because the agent doesn't believe it's true and ask him if he's making it up, but because of the lack of physical evidence. Eyewitness who saw the child alive on the side of the road after my client had said he'd killed him. That's the type proof in this case that will give you reasonable doubt. And you're going to hear that once the state got their, quote, confession by telling them, if you tell us what we want to hear, you can walk out that door, paraphrasing, they pretty much shut down the investigation. They did do a thorough GPS search for a radius of 6 miles. But they didn't do thorough searches outside that. They received a report from a lady that was approximately a mile away that her 4-year-old's footwear, boots, were taken off her porch that same morning that Joe Clyde went missing. And you would hope that they would take the dogs out there and try to pick up a scent and follow where those boots may have gone. But did they? Nope. They received a report that a young girl at another residence reported seeing a young boy in dirty pajamas. And you would hope that they would go out, take the dogs, try to pick up a scent, and follow that to see if they could find this child alive. But they didn't. They drove up and down the road, but they didn't do a thorough search. You'd also hope, based on a report, that other than bringing dogs out there and doing a GPS search, that they would have searched the camper in that yard where a sex offender lived, in the very yard the little girl reported seeing the boy in dirty pajamas. But did they? Nope. They didn't even talk to the next door neighbor, a man who lived in a shed without plumbing. They didn't talk to him until almost 2 years later. And you're going to hear, in regard to that, how biased this investigation was. The state did not want evidence that my client confessed falsely. They didn't want to know what happened. So they confront this neighbor with the fact that their video study showed a vehicle leaving his driveway around 5 in the morning. The only vehicle that left either drive before 6. They asked this gentleman to let them have the phone so they could determine his location. Do Google location service and that technical stuff that I don't know about. But they asked him to do that, and they're going to testify that he wouldn't let them have the phone. They're going to testify that he told them he was concerned there might be information on his phone that would be incriminating. Did the TBI follow up on that, get a search warrant, and check that man's phone to see where he was? No. So I submit to you in this case, you're going to hear that they took a mentally ill person and essentially tricked him into making up a confession that they figured out pretty quickly was not true. No blood evidence to indicate he beat the kid for 15 to 20 minutes in the living room. No blood evidence in the trunk of the car. The car didn't even leave like our client told him he did, because they've got a neighbor's video that shows it didn't. So what does the state do if they can't show he took him in the early morning hours off? Then they have to look and say, well, let's get a search warrant and see if he buried him in the yard. Wasn't in the yard. So what do they do then? Well, man, we're in a bind. Let's say that he called the police out there, and then after the police got there, he drove off with the body in the trunk of the car and got rid of it somewhere. They're going to ask you to believe that if you kill a child, you're going to call the police out there when you still have the body in the trunk of your car. That's the most absurd thing I've ever heard. They don't have a case. They keep trying to change the facts to get to it, and that's what you're going to see in this case. They realize the confession's false. So they dig in the yard. Oh boy, we're going to find him in the yard. Nope, he's not in the yard. Well, let's just say he was in the trunk of the car when the police got there, and that the defendant called the cops and had them come out while he had the body of the deceased victim in the car. All that's going to show to you that the state cannot meet their burden beyond a reasonable doubt. I'll ask you to use your common sense as you listen to the videotape confessions. You will see that they convinced my client that he had killed his child. You will see that they had him so convinced that he was crying and saying, my daddy's going to kill me. You will see that my mentally ill client was convinced that he had killed the child, and so he tried to speculate and make up what he thought would happen. And it sounded good when you first listened to it. Beat him 15 to 20 minutes in the living room, wound on his head running down both sides of his face, wound on his leg from being thrown against the coffee table, takes him off, walks the body out in the field using his wife's cell phone. That sounds good until you start looking at the actual evidence, and you'll hear there's no proof that her cell phone left. There's no proof that his car went there. There's no blood evidence in the vehicle. There's no blood evidence in the house. And you can use your common sense. If y'all ever had a wound to your head or your face, and you know the capillaries in your head and forehead, when it gets busted open, what happens? Use your common sense in this case, and you'll just see that the state keeps changing. At first, yep, he killed him, put him in the trunk of the car and took him off. Well, no, we got problems there because there's no evidence to corroborate that. Well, he buried him in the yard, so let's get a search warrant. Let's get out there and dig 12 days, however many. Mr. Crouch was out there and Mr. Turnbow. They were both out there digging and picking up tree limbs. But that theory wasn't good. They found out he wasn't there. So now they're going to have to come up with something else. And I think based on what state has told you, they're going to try to argue that he had the body deceased in the car. And then, of course, it makes good sense. If you're a really smart person, you call the police and have them come out. Why you have the body in the trunk of your car? It's just absurd. This prosecution is absurd. and I submit at the end of the trial, you'll see there's no evidence. Thank you.
All right, state may call your first witness.
The state calls Jessica Donnerstag. You need some help turning this around, please. Thank you. We should have Jake's grandson.
Yeah.
Just step right up here, please, ma'am. You will face our clerk and raise your right hand and let us pray for you.
Do you solemnly swear or affirm the testimony you give in this case to be the truth, the whole truth, nothing but the truth, so help you God? Yes, ma'am.
I'm going to ask you to state your full name and to spell it, the last name for us.
Jessica Donnerstag, Donnerstag.
Good afternoon.
Hi.
That was actually my first question, so we're past that. Ms. Donnerstag, thank you for being here. Would you tell us what your occupation is, please?
I'm a speech language pathologist.
Thank you. And where are you employed?
I'm employed with the Dixon County Board of Education,
Okay. What's your current position with the Dixon County Board of Education?
lead speech language pathologist.
Thank you. Will you tell us some of your educational background as to how you became a pathologist? I'm sorry,
Yes.
speech pathologist?
Yes. I have an associate's degree in logistics from the Community College of the Air Force. I have a bachelor's of science in communication disorders with a minor in special education, and I have a master's degree in speech language pathology.
Thank you. In 2018, were you employed by the Dixon County Board of Education?
Yes, sir.
And what was your position at that point?
As speech language therapist.
Okay. And were you assigned to a particular school?
I was at Centennial Elementary School.
Centennial Elementary.
Yes.
And are you familiar with the name Joe Clyde Daniels?
Yes,
And was Joe Clyde one of your students?
he was.
Okay. How long were you Joe Clyde's teacher?
He began, roughly 3 years. There were some breaks in the time that he was coming to our school.
Okay.
So he started out in our 3-year-old preschool class, and he came from August until, I believe, February. And then he re-enrolled the following year as a 4-year-old preschool in November, and then finished up the school year, and then the following year as a kindergarten student.
Okay. Let's talk briefly about his kindergarten year, which would have been the fall of 2017 into the spring of 2018.
Yes.
How many days per week did you work with him that year?
I worked with him at least 3 days a week. Sometimes I saw him more and would, intervene and kind of do some therapy and with other teachers and
Sure.
things like that.
Did you enjoy working with Joe Clyde?
I loved it. He was a really great student.
Can you tell us what type of student he was and how he did?
He was a great student to work with. He was very funny. He was very energetic. He loved to play and he loved to joke around. He really took instruction well. He enjoyed doing the activities that we were doing, and he was he made a lot of progress. He had a lot of potential.
Okay. Tell us some of Joe Clyde's likes and dislikes. Start with the likes first.
He loved to eat. We ate a lot in therapy, especially apples, but really anything. He also loved to play games. I saw him individually, and then I also saw him in small groups with other children. And so he really enjoyed interacting with his peers and playing with them.
Did he have any dislikes?
He did. He didn't particularly like really loud noise and a lot of chaos. He was he liked to be neat. He kind of, he wasn't really into a lot of the messy play. He kind of, if he had something on his shirt, we wiped it off. He enjoyed kind of a calmer atmosphere, I guess.
Okay. What kind of clothes did he like to wear?
He liked to wear his jeans and a little button-down shirt and his boots.
He liked his boots.
He loved his
Were
boots.
they cowboy boots?
They were kind of yes,
Yeah. Okay.
little square-toed boots.
Tell us about what role you played with his education.
When Joe came in, I was part of a team that reviewed assessments and helped determine eligibility. That's done as a team with different members that have different roles. And then from there, we develop a plan. And then that plan kind of explains where he's at, and then what we're going to work on, and kind of how we're going to address those goals. And so when he started, I did push-in therapy, where I went into the room and kind of worked with a whole group and did therapy there. And then as he got older, I did more individual sessions and small group sessions.
Okay. When you talked about being on a team that developed a plan for Joe Clyde, what is that plan called?
It's called an Individualized Education Program. A lot of times we call it IEP for short.
And what is an IEP? What is that?
It lays out what we're going to work on. So students that, if they've been determined to have an educational disability, then we develop the IEP, and that plan just lets us it guides us. It's an agreement of, these are the goals that we're going to work on. We're going to do it this many times a week. This is who's going to be involved. And then we take data and we track that progress and then adjust it every year.
Does the plan include assessing his current skill levels in different areas?
Yes.
And does this specific plan do so?
Yes.
Okay. Your Honor, may I approach the witness? Ms. Dunnerstad, can you identify this document, please?
So this was his latest IEP. It also has a minutes note and then some evaluations that were done that year as well.
Okay. And Ms. Donnerstag, on the second page, not the title page, but the second page, is that your signature?
It is.
And you, as you've already testified, were one of the team members that developed this plan?
Yes, sir.
And are you familiar with the contents of his plan?
I am.
Okay. And I want to spend just a moment going over some of his evaluation, okay?
Yes.
Let's first turn to what's known as the Dickson County Schools Physical Therapy Evaluation, which has listed communication, posture, range of motion, and gross motor skills. You see that page?
I do.
In this plan, can you identify what his general communication level was?
At this, it says that he was able to communicate during the evaluation with eye contact, gestures, and pointing. He showed a desire to count but could not articulate any numbers. He tried to say blue and said the word ball during the evaluation.
In this plan, the initial evaluation was in the fall of 2017, is that correct?
For the physical therapy?
Yes. So, and we read what his communication level was when this plan was submitted. Had he gotten progressively better during the course of the school year?
Yes.
And can you describe for the jury how he progressed?
He aggressed both with his verbalizations and then with his nonverbal communication skills. So when he started out, he really had mainly spoken a lot of vowels with not a lot of variation. And he became where he was kind of varying that. So, counting may have been a ooh, ooh, e, where you're not really hearing those consonants, but you are hearing, you can tell that it's a different number. It's not the same sound every time. And then he was also able to say more words. He was able to articulate more, especially familiar words that he used quite often. And then he was also able to do some functional signs to request if, yellow, more, eat, some of those. He also had some picture stimuli or some choice boards that he could identify, or picture cards that he could communicate that way. And then just the back and forth conversation also kept progressing.
Okay, thank you. Let's talk about gross motor for just a moment. What was the summary of his gross motor skills? It's on the bottom of that page.
Of the first one.
Yes, ma'am.
Okay. I'm just going to read
Sure,
this.
please.
Is that okay? Joe was evaluated using the movement ABC for age band 1, which is 4 to 6 years. He was 5 years and 3 months at the time of testing, and therefore tested as a 5-year-old. Joe's scores on this test fell in the first percentile when compared with other children his age. The test has 3 sections: manual dexterity, ball skills, and static and dynamic balance. Joe had difficulty in all sections, but had the most difficulty in the sections that were timed due to his high level of distractibility. I had to give him several reminders to return to task. He had a hard time with catching a beanbag as well as rolling a ball at a target. Upon assessment of Joe's gross motor skills outside of the test given, he demonstrated the ability to jump up, jump forward, jump 3 times in a row, and jump off, but was not able to hop on 1 foot. He was able to walk on a balance beam for 4 steps, walk on his toes, and walk on his heels. Joe ascends the steps with a reciprocal pattern with a rail and descends with a mark time pattern with a rail. He had increased difficulty with ball skills, coordination, and motor planning activities. Joe's run pattern has not quite developed as a mature running pattern at this time. Joe definitely struggled the most with any activity requiring hand-eye coordination, whether that involved fine motor or gross motor activities.
Thank you. Now, first, let me move that as exhibit number 1 in the state's case, Your Honor.
All right, we'll mark that. This is a copy of the individual and educational plan, and we'll mark that as exhibit 1.
Thank you. Ms. Donnerstag, during the school year, did you take individualized notes about Joe's progress and his strengths and weaknesses?
I did.
Okay. Can you identify these documents, please?
These are my notes, my personal notes.
Thank you. And there's lots of notes here, but I want to turn your attention specifically to what you have labeled as the alphabet locks. What is an alphabet lock?
An alphabet lock is, they're little plastic, multicolored locks, and they have a corresponding plastic key. And so there's a letter and a picture on the lock, and then there is a letter, a lowercase letter, and on these I think we put the uppercase letter as well on the key. And so the target of the task is to match the appropriate lock and key, and if they are a match, then you can put them in and the lock pops open.
Is this what you're referring to?
Yes,
That's an alphabet lock?
it is.
The lock and the key? All right. And is this the type of lock and key that you used with Joe Fly?
It is.
And you made some specific notes about his performance using the lock and key. What did you say?
I said that alphabet locks could match upper and lowercase letters, had difficult time manipulating key and lock, discussed poor fine motor skills with OT, which is the occupational therapist. Kelly said she was aware and has been working on fine motor skills.
So I believe you actually witnessed Joe Clyde successfully get the lock into the key into the lock, is that correct?
I did. It was labored. It was a difficult task. The particular task I was actually doing in a group therapy, and there was a marked difference between what he could perform and what his same-aged peers could perform as well.
Okay. And I will move the lock and key as the collective exhibit.
Mark it as Exhibit 2, collective.
I'll also move a copy of Ms. Donnerstag's notes as collective exhibit 3.
For the record, we're gonna make the lock and key as a collective exhibit number 2, and then the copy of that, what you're saying is exhibit 3.
Yes, these are the handwritten notes of
Handwritten
Ms.
notes,
Donnerstag. Talking about Joe Clyde's motor skills, fine skills, speech skills, you said he was in the 1 percentile. He was markedly different than the other children in how fast he could perform tasks. Is that correct?
Yes.
But what about his ability to do some of these tasks quietly? Was Joe quiet?
He was not quiet. With the fine motors, that's, kind of your small hand movements, and your gross motor are your big movements. And he had difficulty with both of those areas. So when he did something, it typically was kind of loud and wobbly and just kind of overall coordination.
Was Joe in any form or fashion stealthy?
No.
Okay. Now, you also, in documenting your file that you kept on Joe Clyde, took some photographs of him. Is that correct?
I did.
And I'm going to ask you to turn your attention to the screen. Let's see if you can identify some of these photos for us, please. Are these 3 photographs of Joe Clyde that you took?
They are.
And were these photographs taken in your classroom?
They are.
Now, are there other students in the classroom while you're working with Joe Clyde?
On that particular day, I do not believe so. But I did see him. I saw him individually, and I saw him in a group as well.
And can you explain kind of what he's doing in the 3 separate photographs?
In the first one, it's a sorting task, and so there are different Marvel Avengers, and there's a top and bottom, and it's kind of like a memory game where you remove the cup and find the match and put them together. He's kind of really proud of himself in that picture, smiling. In the second one, we completed a puzzle together, and I believe he was pretty happy with himself in that one as well. And then in the third one, we're having a snack, and I think he has a big bite of apple in his mouth.
And are these the shirts that you're referring to that he likes to wear, the button-down plaid?
Yes.
And does this photograph represent what we are seeing on the screen?
Yes, sir.
And I would move this photograph as exhibit number 4.
Yes, sir.
Mark it as Exhibit 4.
And Ms. Donnerstag, I think you also had some video clips of while teaching Joe Clyde, is that correct?
Yes, sir.
And if we could go to the next slide. Well, let me back up. Before we go to the video, can you identify the photograph on the screen?
Those look like the boots that Joe wore.
Okay, now this is not in your classroom,
No, sir.
but those do look like the boots that Joe wore.
They do.
Does this photograph represent what we are seeing on the screen?
Yes, sir.
I will move that as exhibit 5.
Mark it as Exhibit 5.
All right, I think we now have a video. Pause that for a second. I need to make sure the volume is loud enough for the jury to hear, because there is speaking. I'm going to start the video over. I'm going to step out of the way.
Okay, do we have them all? Can you count them? Let me hear them count. E. Go ahead, baby. Oh, man. There you go. Okay, we said 1, 2, 3, 4. Good, what's it? 5. What's it? 6, 7, 8, 9. That's all? Good job.
So, Ms. Donnerstag, are we seeing kind of layered teaching method here? We're counting, identifying words, saying words, placing objects? But does that have a name for that?
Yeah, so for here, we're just working on just basic communication skills. What I'm seeing on here is that he was varying those words. They were kind of, some of them you could tell what they were, and some of them were kind of word approximation. He was putting two words together with a ball. On that, you can tell that he is participating in a back and forth communication with me. So even though he's not verbalizing like we would expect, he's anticipating what I'm going to say. He's watching me. He's responding to my reactions. He's really doing well with that. And then he's also counting and matching the shape with the silhouette.
Thank you. In your best representation, how did he say the word 5?
It was primarily vowels, not a true F or V sound on those.
Did you ever hear him count past 10?
I don't believe so.
Okay. I think we have another video clip as well.
Okay, come here. Letters. And go. Joe. Joe. Hey, I want to hear you. A. Uh-oh. I don't hear. Say it. A. Your turn. E. Good job. E. Good. E. What's next? A. F. Ah. Good. G. H. I. What is it? J. K. L. M. What is it? A, B, C, D, E, F, G, H, I, J, K, L, M, N, O, P, Q, R, S, T, U, V, W, X, Y. What is it? Z. Good Good job, Joe.
And what's this exercise?
This was letter identification and naming. We were working on a lot of just kindergarten skills as well as communication.
And although I not necessarily could hear the exact letter he was saying, he was pointing, is that correct?
He was pointing. He was pointing kind of in a, with the pointer, and he was also tapping the letters appropriately, and he was doing it kind of in the pattern that you would expect. So even though he wasn't maybe verbalizing it as clear, he was demonstrating the understanding and doing the skill kind of in a receptive or nonverbal way.
Okay. As a side note, is this about the length of hair that Joe Clyde kept during the school year?
I believe so. He typically had shorter hair.
Yeah. How would you describe that haircut? I've heard it referred to as a burr.
A burr or a buzz.
Okay. And I think we have one more video.
Hey, Joe. What is it that you're wanting? Hey, Joe, look at me, buddy. Look, I don't have an apple. I'm so sorry. Do you want me to bring you an apple on Thursday? Are you so mad at me because I don't have apples? Hey, be nice. I'm sorry. I really am sorry. Don't be so mad. We're gonna play a fun game instead, okay? No, you want an apple more than anything? Be nice, okay?
And Ms. Donnerstack, did those 3 video clips accurately represent videos that you made of Joe during the course of the school year?
I made all 3 of those.
Okay. Thank you. I'm going to move a copy of the 3 videos as the next exhibit.
Exhibit 6.
Do you know Alex Nolan?
I do.
How did you know Alex?
Like I said, when at Centennial, I pushed in to the preschool class. So during speech and language therapy time, I would go in and I would kind of work with the whole group and do some literacy and language and speech skills. Alex was enrolled as a peer in the preschool class. And so in the 4-year-old class, they came 4 days a week or 3 days a week. So he was actually enrolled in that peer program.
What does that mean to be enrolled as a peer?
In the special education classroom that we had, the way that we had that particular one set up is we had students that had educational disabilities that needed some supports and had IEPs and goals. And then we also had typically developing peers so that they could be an appropriate model so that we could, children learn best from each other. And so the peers kind of help us teach those skills to our students that had the IEPs.
And how would you describe Alex as a model peer?
Alex was an exceptional peer. He was he was just a kind, sweet child. He is one that if a student was struggling, you could always, hey, why don't you go over there and play with him? And he would go over and, here, buddy, let me show you how to do this. So he was very kind and he was very patient and just really, as far as a peer comes, you couldn't have picked a better peer for our students.
From your observations, did Joe Clyde like to be around and near Alex?
He did. Alex, I would take Alex occasionally and, have him interact and, just kind of see how they communicate. And Alex loved being around Joe loved being around Alex.
Okay, thank you. Just a couple more things and I'll be finished with the
Okay.
questioning. You described how Joe Clyde was progressing as you would work with him through the week. On a day-to-day basis, you would observe him progressing. What would happen after going home for a weekend or not seeing you consecutive days in a row?
When he would come back to school on Monday or after a break, it took a lot more encouragement to get him to verbalize. And so, by the end of the week, towards the end of it, it came a little easier. And it was, he kind of spontaneously gave me more. And so, but then when we come back, it kind of took me a little bit more. It was, the skills seemed to regress over those breaks in the weekend. And then we would kind of build up throughout the week.
Do skills regress when not being practiced?
Yes.
And you also made a couple of other notes in one of the exhibits we've already marked in your handwritten notes that you had observed over-medication of Joe Clyde.
Yes.
And what did you observe?
You want me to say or just
Sure.
read? Okay. Well, I can read if that's okay, and that way I don't speak. Let me find it.
And again, these are from your handwritten notes, which we've made as an exhibit. Is that correct?
Yes.
Okay.
Okay, so I had marked becoming more easily understood within context, spontaneous speech increased. And then I wrote, Joe has been extremely tired during therapy, asked if he was sick, and he responded no. Asked if he stayed up all night, and he responded no. Then imitated drinking something and said, in. And I asked medicine, and Joe nodded his head yes. At bus duty, Joe fell asleep, and I asked Alex why he was so sleepy. Alex stated that it was his medicine. I asked, is he sick? And Alex said no. And I asked, then why did he take medicine? The bus was then called, and Alex jumped up and said, gotta go, and hurried off. And then I just wrote strange reaction. Checked on Joe next day, extremely lethargic, reported to school nurse, went into the lunchroom. He was falling asleep while eating, went back to the nurse, went and got Joe and took him for the nurse to observe, appeared way over medicated. Nurse contacted parents. Next day, appeared more alert and back to his normal self.
Thank you. Thank you for being here today. I'll pass the witness.
Cross-examination?
Joe Clyde, he was not completely nonverbal, was he?
There's different definitions of nonverbal, so I would have to ask your definition of nonverbal.
Well, I mean, he could talk to some degree.
Correct. He had verbalizations that he made.
And if he was prompted, that made it easier for him to verbalize. Is that correct?
He made verbalizations prompted and unprompted.
And unprompted.
Yes,
and
sir.
one of those was, as he was counting, he counted to 5, correct?
Yes.
And he counted 1, 2, 3, and then he said 5, and he didn't say it. You said he left off the F, essentially.
I believe so. I think I wrote in my notes, but it was on, oo, e, or, I, something like that.
That's what he said, like IVE, as opposed to with the F, correct?
I believe so.
And so when he verbalized that on the screen, you could tell that he was saying 5.
I could tell within context. I knew that he was counting, so I was anticipating that number. Yes.
All right, and he, as far as his gross motor skills and his fine motor skills, those kind of things, he had a hard time doing sort of small tasks, hand-eye coordination things, correct?
Correct.
But he could move around fairly well. He was not stable, as you said, but you could see him on the video. He was getting around the room, moving around the room fairly easily, correct?
He could walk, yes.
Yeah.
That-
And he could use his arms and his hands. He was holding the pencil and using it to point out the things. And
He could use it. Look, it seemed delayed from my standpoint because he was kind of leaning up on the wall and kind of hitting it with a uncoordinated task, but
Sure.
he could do it. Not,
But he was
no, it wasn't
grasping.
typical, but he
Okay.
could do it.
understand, it wasn't what you would expect from a 5-year-old.
Correct.
But he was grasping that pencil. It was a sort of a long pointer shaped like a pencil.
Yes, sir.
Is that right?
Yes, sir.
And he was grasping that with his right hand, and he was pointing with it. And as he, in the other video, moved around the room, he moved over by the door, didn't he?
He did.
And when he got over by the door handle came to somewhere in his chest area. Is that right?
I believe so.
Okay. So the door handle was where he could easily reach it with his hands, wasn't it?
It was,
Okay. So he could grasp that door handle if he wanted to, couldn't he?
if he wanted to.
And he could turn that door handle and open the door, couldn't he?
Yes.
So he could have walked out of that room had he wanted to do that. Have you seen, well, I mean, you nodded, you didn't,
Yes, sorry. Yes, he
Okay,
could
I'm
open the door.
and so he could walk out of the room if he wanted to.
Yes,
He could use doors.
yes,
Okay. And you've seen him go in and out of rooms using the door handle, haven't you?
yes.
I'll pass it.
Redirect.
Mr. Dunnerstag, you said you've seen him use doors and go in and out of doors. Did he ever escape from your class?
No,
Thank you.
Anything further, Mr. Tyler?
No, Your Honor.
Thank you, ma'am. You may step down. Are we finished with her as a witness? Do we need to release her?
Release.
All right, thank you, ma'am. You are released. You may leave or you may stay as you choose. Call your next witness. Let me first ask, ladies and gentlemen, we've been going for a while. Does anyone need a recess before we take up the next witness? All right, call your next witness.
Tony Longton there. I'm sorry, who? Tony Longton.
Raise your right hand and face our clerk to be placed under oath.
Do you solemnly swear affirm the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God?
I did.
Please speak directly into the microphone.
Yes, sir. Good afternoon, Mr. Longton. Would you state and spell your first and last name for us, please?
My legal name is Anthony Longton, Anthony Longtin.
All right, and you go by Tony, is that
Tony,
correct?
yes, sir.
All right. Mr. Longton, what do you do for a living?
I teach high school at Dix County High School, and I also drive the school bus.
All right. And how long have you been driving the school bus?
Oh, Lord. Just again, bus 44's route, I would assume probably 4 years, 5 years maybe on that
Okay.
route.
And does that route take you by the Daniels residence, 1112 Garnish Creek Road?
Every morning.
All right, and that's here in Dixon County, obviously?
Yes, sir.
Okay. Who from that residence rides your bus?
Alex and Joe.
Okay.
Daniel.
They usually ride morning, afternoon, both?
Both.
Usually ride both?
Yes, sir.
How often would they ride?
Pretty much every morning.
Okay.
Every evening, pretty much.
All right. And does your bus, is it equipped with a camera?
Yes, sir.
And does it record kind of behind you what the students are doing as they're moving or whatever?
It is equipped with 3 cameras, all rear facing.
Okay. Let me show you a clip here. Does that, I know it's just a still image there, is that your bus? Can you tell?
Yes, sir, it is.
All right. And is that Joe Clyde that we see laying down there in that seat?
Yes, sir, it is. That's his assigned seat, his and Alex.
Okay. And Mr. Longton, this is from April the 3rd of 2018. Is that correct?
Should be, yes, sir.
And who do we see there in the foreground? Kind
That
of?
is Joe.
All right. Who did someone meet them at the end of the driveway that day? Do you recall?
Should have been Aunt Joyce, I believe.
I believe you could hear something about Alex saying, "That's my Aunt Joyce" or something like that.
Right, I believe that's correct, yes,
All
sir.
right. Who usually met them there, if anybody, at the end of the drive?
It was usually Aunt Joyce every day.
Okay.
She'd usually bring him there in the morning and pick him up in the evening.
All right. You're going to ask to make a copy of that video at the next exhibit.
We'll mark it as Exhibit 7, I think it is.
Yes, sir.
All right, so what we've just watched, that was video of Alex and Joe Clyde getting off the bus on 4-3, correct?
Yes, sir.
Did you pick them up on 4-4 to go to school?
No, sir.
All right. Anybody at the end of their driveway when you went by?
No, sir.
All right. Did you ever notice anything odd that day? Have any interactions with Joseph Daniel or any of them on the morning of 4-4?
That morning, I pulled up to the bus stop. I noticed that nobody was there. I looked behind the house to see if there were anybody coming out there. I looked toward the front. Didn't see anything moving normal, so I just kind of moved on. But when I went to look up forward, I did see his vehicle up at the next stop up the road.
And when you say his vehicle, are you referring to Joseph Daniels, the defendant in this
Yes,
case?
sir, a maroon. I can't remember what model, but I believe it was a maroon car.
Okay. And you saw it up at your next stop?
Yes, sir.
And about how far was that from 1112?
From 1112.
From 1112's Garners Creek, the Daniels residence.
Oh, the Daniels
I'm sorry.
residence. Let's see, 1, 2, 3, 4 houses up, I believe it is.
And his car was up at that house.
Yes, sir.
What was he doing? What was going on? If you
The
know.
kids, when the kids got home, said he was asking if anybody's seen Joe, that he was gone, I guess left the house or something.
All right.
The best I can recall, that's what the kids had said.
Okay. And then you went on about your bus route. Is that accurate?
Yes, sir.
That morning? Okay. And then, did you or were you part of, or was it Did you get part of the shuttles that were shuttling volunteers around?
Yes, sir.
All right, and was that actually your idea to
Yeah,
get the
I
tell us how
mentioned that
happened.
night. Yes, sir.
All right, tell us about that. What happened?
We got there the first day whenever we heard everything was gone. So when I got up, I come back around on the old Garners Creek, that's toward the end of the route, and I seen one of the deputies, and I stopped and said, "Hey, what's going on with that?" And they said, "Well, it seems like little Joe's missing." So we got there that night. Later on, just to see if anybody could help, and I believe I said to Jeff Bledsoe at night, I said, all these deputies moving around, they were looking for trailers and everything else, and I said, we ought to see about getting these school buses out here. We could use mine and we could shuttle people around with it, and I guess that was a good idea, and there they went from there.
All right, and so did the school lend buses essentially to move searchers around?
100%, they were all in for it.
And how many days did y'all run buses shuttling people back and forth different places?
I can't give an exact days. I know I ran 1, 2, I think 3 different times. I believe it's 3 different searches I believe I ran.
Once in April and then searches after that?
Yes, sir, I believe that's correct.
I believe there was a search in May as well.
I believe so. That was on the upper side, yes.
All right. That's all I got.
Okay.
No questions for this.
Thank you, sir. Mr. Longton, you may step down. We're releasing Mr. Longton from the subpoena.
Yes.
You are released from your subpoena. You may stay or leave.
Thank you.
Call your next witness.
Chelsea Lampley, Your Honor.
Turn it over.
Yes, Your Honor.
Court's action, please.
You solemnly swear or affirm the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God.
You will speak directly into that microphone, please.
Would you state and spell your first and last name for the court reporter, please?
Chelsea Lampley, CHELSEA LAMPLEY.
Where do you work, Miss Lampley?
In Dixon 911.
Okay, and what do you do there?
I'm a dispatcher.
Did you receive a call about a missing child on April the 4th of 2018?
I did.
And who called, if you recall?
The defendant.
Okay, and was that Joseph Daniels?
Yes.
All right. And obviously those calls are recorded, aren't they?
Yes, sir.
All right. I ask you to listen to this call.
Call 1 on Wednesday, April 4th, 2018 at 6:22 a.m. with a GMT offset of negative 300 minutes. Agent ID is extension is 106.
Where is your emergency?
This is Dixon County 911.
Yes, sir.
Okay, I was on 112 Garners Creek Road, and my son has been escaped, and we cannot find him.
Okay, how old is your son, sir?
He is 5.
Right, you said he was 11,
He
12?
has autism. Yes,
Okay, and you said he has autism?
yes.
Okay, how long ago was he last seen?
Last night,
Okay, all right. And what's his name?
his name is Joe
What's his last name?
Daniels.
What was he wearing last night?
He was wearing pajamas.
What kind of pajamas? What do they look like?
So I have to put that, I wore that,
Do you know how he got out of the house?
He must have locked the door.
Okay.
And he got out.
What's his date of birth?
7/3/12.
Okay, sir. And you said his name was Joe. What was his last name?
Daniels.
Daniels.
Yes.
Okay. And what's your last name, sir?
Daniels.
Okay, what's your first name?
Joseph.
All right, Joseph. And what does he look like?
He's got blonde hair. And blue eyes.
Okay.
And,
Okay, blonde hair, blue eyes. Anything else? How tall is he?
he's about, I would say 4 feet tall.
4 feet tall. How much does he weigh?
65 pounds.
65 pounds. Okay.
Yes.
Okay, do you know anywhere where he would go from your house?
I don't know, because we don't know any evidence except for one neighbor.
Mm-hmm.
So I don't know where he would have gone.
Okay, is he nonverbal or is he verbal?
It's nonverbal.
Nonverbal?
Yes.
Okay, and how severe is his autism?
We also understand whether it's some medical help that even matters, so, but it's not so severe, but it's pretty significant. Where he can't talk and he's unable to communicate.
Okay.
And we have to, he tries to pay himself, but we have to pay them.
Okay, all right, sir, and what's your phone number?
629 867
Mm-hmm.
6984.
Okay, and did he take anything with him out of his room?
I had seen that they took out his room.
No stuffed animals, no blanket or anything like that?
No.
Okay, all right, Joe, we're gonna get him in route to you, okay? Just hang out right there at 11:12, we're gonna get him out there to you, okay?
Okay.
All right, thank you.
All right, so Ms. Lampley, working at dispatch, have you received 911 calls about children that were missing before?
Yes, sir.
All right, have you received multiple calls of that nature?
Yes, sir.
Had some of those children had autism?
Yes.
All right, did you find anything odd about this phone call?
He seemed extremely calm.
And when you say he, who are you referring to?
The caller,
And that's
Joseph Daniels.
So, is that something you noticed when you were speaking with him?
I did.
All right. And just a couple things, because his voice on there was a little hard to hear. Did he say, "My son escaped and we cannot find him"?
As far as I know, he said, I think he got out.
Okay. What about, he said about 3.5 to 4 feet tall and nonverbal, correct?
Mm-hmm.
All right. Your Honor has to introduce a copy of that.
Mark it as Exhibit 8.
And Mr. Etheridge, could we play that call again, just to get the how he got out part?
Call 1 on Wednesday, April 4, 2018, at 6:22 a.m. with a GMT offset of -300 minutes. Agent ID is extension is 106.
Where is your emergency?
This is Dixon County 911.
Yes, sir.
Okay, I was on 112, Blind Creek Road,
Mm-hmm.
and my son has been escaped, and we cannot find him.
Stop.
Okay, how old is your son, sir?
Did you hear that time him saying, "My
Okay.
son's escaped and we cannot find him"? All right. Is that typically what you hear when someone's calling? Do that in this call?
I did.
And what kind of data does it log?
It logs the caller's phone number, location, the type of event that is going on, their Latin long of where they are at the time of the call, and a short narrative of what's going on.
And does it also log officers on scene and kind of what time they get there, that kind of
It
thing?
does. Every unit that's en route or assigned.
I'll pass you the document here. Is that the CAD card for this case?
It is.
All right. Your Honor has to make that the
And this call, my client called you to get police to come to his house.
Yes, sir.
That's all I have.
Redirect? Thank you, ma'am. Are we releasing her from her subpoena? You are releasing your subpoena, you may go back to.
Thank you.
All right, you may call your next witness.
Judge will have to have a brief jury out before the next.
All right, ladies and gentlemen, this will probably be a jury out hearing, and you can go ahead, and we'll take a recess after this to give you a chance to stretch your leg and have a restroom break. You'll step across the hall, please.
Your Honor, may counsel be excused briefly
You
for
bet.
restroom break?
Or you want to do that, let one of the other counsel argue this, whatever it is we're about to take up, or do you want to take your recess before we take up the matter? You need to go to the restroom, let's just go ahead. Let's go ahead and take our recess. Let's take a, well, this will be our afternoon recess, we'll take a 15-minute recess.
All rise. Court of recess.
Recording stopped.
Okay, who's staying with the jury tonight?
referring to her confession that corroborates Mr. Daniels' confession.
Well, the statement that was made implicating the defendant in something was what we had ruled, or what was the objection was to. I don't know what these statements are that she makes on this recording. If they're not being introduced to prove the truth of the matter asserted therein, then they're not actually hearsay. If they're not a statement implicating Ms. Daniels in anything, then it's not a statement against penal interest. So I don't know particularly what, the basis would be to object to it. I mean, have you heard and reviewed this statement or this body cam?
We have, it's been some time, but my motion was that in regard to extrajudicial statements by the co-defendant because of our right of confrontation. Now, if they want to play her statements and then put her on the witness stand and let us cross-examine her, then we don't have a real issue. But we will be denied the right to confront or ask her about anything she says on this video. And that's a pure violation of Crawford.
Why is it necessary to play the Crystal Daniels portion of this tape?
It's not, Judge.
I think in order to be consistent, I have excluded the testimony of the mother of this child that alleges her child said something because of the fact that I thought that was hearsay. And it would seem to me that under the circumstances that in erring on the side of caution, it may be better to allow you to play that portion of the tape with the exception of any statements made by Crystal Daniel, and then we'll go from there. So I'm going to sustain Mr. Lockhart's objection to that portion of the body cam footage that had to do with Crystal Daniel's statements, but you're entitled to play the rest.
And we're fine with that. Point being was the motion which we agreed to was not litigated, so this is here's where I'll go.
I'm not making a ruling on anything except for the fact that this particular portion of this is not, I'm not excluding it based on what was said at the prior hearing. I'm excluding it based on the fact that erring on the side of caution, and I want to make sure that there's nothing that comes in that would deprive the defendant of his right of confrontation. So at this point, I'm just going to deny allowing that portion of Crystal Daniels' interview by Sergeant Baker, and we'll allow you to play the rest of the body cam footage. Was there anything else we need to take up before the jury comes back?
Yeah, what I was going to say is because there hasn't been a ruling, we haven't redacted this from the video, so we need a few minutes.
All right. Do I need to allow you to have a recess to do that, or can you do it right here? Let's get it to where you can redact. Go ahead and do that. We'll just give you a minute. Rather than me step off again, we'll let you do it right now.
I don't think about 15 or 20 minutes.
15 or 20 minutes?
Just to confirm, play it back in its entirety to confirm there's no statements.
Well, under those circumstances, I'm not going to sit here for 15 or 20 minutes while we do that. Is there anything else we can address while he's working on that?
I don't know of anything else. I'll just state, we will request an out of jury before they play any recording of Crystal Daniels saying anything. And also would request that we have an opportunity to view the redacted video.
I'm going to give you an opportunity. What I'm going to do is I'm going to give Mr. Etheridge, in view of this, an opportunity to redact the video. I'm going to give you an opportunity while I'm off the bench for you to review it. And then I'm going to ask the bailiff to let me know as soon as you're ready. I will send word to the jury that we're going to take a little longer in order to take care of some technical difficulties and that they'll just need to take a longer recess. And as soon as that is done, then we'll come back. As far as you objecting, we'll note that you have a running objection to any supposed statements of Crystal Daniels coming in, but we'll have to have a hearing on each one for me to determine that. I did not interpret the statement that was made by the state agreeing as anything other than the alleged statement that she gave, which tended to incriminate your client, and that was why I tend to think that the state is correct that we only dealt with that one issue. If you're saying that there's a statement that Crystal Daniels made that was not a part of her confession, that you still object to it, then I'm going to determine, first of all, whether or not that constitutes some sort of an exception to the hearsay rule or whether it is in fact hearsay. You have a right to confront your accusers, But if there's nothing accusatory in that statement, then I'm not sure it deprives your client of the right of confrontation. So we'll deal with them on an individual basis.
Yes, sir. And Judge, just so you know, I don't think there's gonna be another recording that has her voice in it, but we will confirm that. We've redacted her from every other thing we have. So.
All right. Well, let's give Mr. Etheridge an opportunity to try to redact this, and I want Mr. Lockhart to have an opportunity to view it and determine whether or not it meets his, if there's any objection to it, then we'll come back in and we'll look at it. So just, I'm going to ask the bailiffs to let me know as soon as you have this ready.
All rise. Court's in recess.
Recording stopped.
Hey, do any of y'all recall receiving the redacted, confession of Joseph? Like 3 weeks ago? No, you're young, so I would anticipate you're probably right.
Clerk's office.
Gentlemen, well, before we start watching that video, I had mentioned that the jury has to be out of the Montgomery Bell hotel in the morning early for a church camp group to come in. I originally said we'd start court at 8, but they're going to bring them breakfast here. So we're going to have them eat breakfast at 8 o'clock here and start court at 9 like we had planned. So
How long will we go on Saturday?
I'm not sure. We probably will not go till late in the afternoon. I've got some place that I unfortunately have to be, that probably mid-afternoon at the latest. You have some issue or?
I don't care how long we go, I just.
This Saturday,
Witnesses and that type of thing.
this Saturday will be more difficult for me to go later than the next Saturday, so if we're still going. Fine with me. This is what I had hoped to avoid. second of it?
Well, if we fast forward, we can't hear what's being said. Oh, we could, I guess, but like, beep, 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 like that, squeaky voices, chipmunks. We're fast forwarding something, man.
While we're waiting on this, are there any other issues such as that recording that we're gonna have to deal with? I'd rather do it, outside of our regular court hours at this point. And I understand this was unexpected because of the difference in interpreting what had taken place before regarding Mrs. Daniels, but primarily I'd like to avoid having the jury sit back there wondering what's going on. All right, are we ready?
No, he found the portion where it was her voice, so he's taking that out.
That's like a muted. That's muted, you don't see her. But you'll see her.
You're gonna see her.
Yeah.
Yeah, I don't care if you see her, as long as we don't hear what she's saying, that's fine.
So are we ready?
Yes.
Right. He's gonna play it muted, Your Honor, and if it's an exhibit, I'd ask that the exhibit be muted also.
All right. Officer Howell, can you communicate with them to tell them that are we ready for the jury? All right, let's let the jury come back in then.
Recording in progress.
We're ready. Thank you. You may have a seat. Ladies and gentlemen, let me apologize to you for the long delay. During the trial, I have to make rulings on certain types of evidence, and sometimes that means to exclude certain portions of a recording. This delay is my fault. You should blame me and not either side in this case, because I ordered them to redact certain portions. A redaction means they remove, some of you probably know that, but it means that they remove certain portions of that I've ruled you shouldn't hear. There are good reasons for that, but unfortunately, this is an issue that came up because it wasn't clear about something that in a pretrial motion, we normally would handle this pretrial, and this is just an unusual situation that came up. So don't hold it against the defendant, don't hold it against the state, hold it against me if you're going to hold it against anybody for the delay that we've had. But now that they have that fixed, we are ready to proceed, I believe.
On state calls Nicholas Dearman.
Afternoon, if you'll come right around and raise your right hand and be placed under oath.
Do you solemnly swear affirm the testimony given in this case be the truth, the whole truth, nothing but the truth, so help you God?
Officer, if you'll speak directly into that microphone when you sit down, that'll help us to make sure everybody can hear, all right?
Yes, sir.
Deputy, will you state your full name for the court, please?
Nicholas Dearman.
Thank you. And where are you employed?
I currently work for Humphreys County Sheriff's Office.
Thank you. How long have you been employed there?
Just under a year.
And previously, did you work for the Dixon County Sheriff's Office?
Yes, sir.
And how long did you work for Dixon County?
Approximately 4 years.
All right. Were you working for Dixon County on the morning of April 4th, 2018?
I was.
And do you remember what unit number you were for Dixon County?
I'm not 100% sure. I believe it was 503.
503. And on the morning of April 4th of 2018, were you dispatched to Garner's Creek?
I was.
And tell me where you were when you received the call to go to Garner's Creek.
I was at the Trails Apartments in Dixon. I was converting from my personal vehicle into my patrol vehicle when the call came out.
Okay. Were you with anyone when the call came out?
I was with Sergeant Daniel Baker.
Okay. Was he your shift sergeant for the day?
He was.
Was he also dispatched to Garner's Creek?
Yes, correct.
Did you both go there?
That's correct.
And did you check on scene at approximately 6:33 a.m.?
Yes,
Thank you. Were you wearing a body camera during this interaction at Garner's Creek?
I was, yes.
All right. And before we get into the body camera video, just give us a brief description of what you saw and who you saw when you arrived.
When I arrived on scene, there was two individuals in the driveway, later identified as Joe Daniels, and I can't remember his wife's name, Crystal, I believe.
Okay.
They were both in the driveway.
Thank you. Now I'm going to reflect your attention to the screen. And show a clip of your body cam video.
Y'all have been around through here? Y'all check under the shed and all that? Does he come to you if he hears his name? Straight up. Have you
you talk to your neighbors? Huh? Their 5-year-old son is missing. Okay. Their 5-year-old son is missing. He's autistic. He's got pajamas on. He got out of the house sometime last night. He should have black pajamas on.
That is for some, I've been out since this morning.
Okay. Just keep your eye out if you see a young 5-year-old boy. He's autistic. He doesn't speak. His name's Joe.
You said he was wearing what?
Should have black pajamas on.
Okay.
If you see him, just call 911 and let us know. Appreciate it.
Okay, Deputy Dearman, who was with you, if anyone, as you were doing kind of the perimeter check?
I was by myself, but Mr. Daniels was close by. He was in the backyard.
He was in the backyard?
He followed me through the backyard, and then he stayed in the backyard perimeter.
Okay. It looked like you had a brief interaction with someone that had a dog.
Yes.
Was that a neighbor?
Yes, he lived behind the Danielses.
Okay. At this time, I'd move this portion of the body camera as the next exhibit, please.
Mark it as exhibit 11, is that correct?
10.
10, I'm sorry.
Exhibit 10. Judge, the redacted body cam will have to be placed onto the Exhibit 10 flash drive that we've just moved in. All right, Deputy, did you also have a body camera in operation as you did a cursory interior search of the home?
That's correct.
All right.
Hello? Hello? How you doing, ma'am? We're just gonna walk through the house, make sure he's not in here, okay?
How are you? Hi, are you? We just gonna look through the house, just another set of eyes. Well, y'all sound pretty confident. We gotta make sure before.
549, negative 5, Alabama, bullet. 62030. I'm on St. Carter Street. Yes, we're on it.
And get some of his dirty clothes.
You look in there, man. You check his room.
It's got a little back over yonder, back over that way, and sometimes you get on that porch over there.
Which porch is that?
Back here in the back, back over the other way.
Copy of this video is the next exhibit, please.
Are we marking this as the next exhibit?
This will be exhibit 12, 11?
11.
So Deputy Dearman, we lost part of the view. Do you know what happened to your body cam?
I had a jacket on that covered it up as I was searching through the house.
And was this just a preliminary search of the house?
It was,
And why do you do that?
just to make sure nothing was overlooked.
Okay. And did you go, which parts of the house did you go through?
Pretty much the entirety of the house. I went in and went to the bedroom to the left initially, as you can see with my camera. And then when I came out of there, I went to the other end of the house where the other deputy, Bledsoe, was at, and just double checked with him, make sure he checked through everything.
Okay. At this point in the morning, there are at least 3 law enforcement officers present. There'd be yourself, and who else was present?
There was Sergeant Baker, Deputy Smith, and then Deputy Bledsoe as well.
Okay. And I think we initially saw Deputy Bledsoe on camera as you entered the house, is that correct?
That's correct.
And I ask if you can identify this photo, please. What's that?
That's the initial entrance into the main entrance to the house, which was through the back door.
Okay. And Deputy, if I could just turn your attention to the screen, is the photograph you're holding the same as what we see on the screen?
Yes, it is.
And I want to kind of point out some spots on here. You're entering the rear of the residence, is that correct?
That's correct.
And what are we seeing here? Are you standing in the threshold of the door?
That's correct. I'm standing immediately in the doorway of the home.
And what do we see here to the left?
It's a toy box.
Toy box. And directly ahead, what's this?
That's the coffee table.
Okay. And what's over here?
It's some kind of like hutch.
Move that as the next exhibit, please.
This photograph,
Yes.
12.
Sorry.
Next photo. Okay, all right. So Deputy, I have some additional photos to show you, since we've had to redact your video. Ask you to identify these photographs for the jury. Is that a still clip from your body cam?
Yes, it is.
And is that from the exterior of the residence?
Yes.
And where are you standing?
I'm standing in front of Daniel Baker's, Sergeant Baker's patrol car to the east of the home.
And can you hold that photo up for the jury to see? And can you identify this man here?
That's Joseph Daniels.
Okay. And what kind of car is this?
It's a maroonish colored Chevy Impala.
Okay. And who is this?
Crystal Daniels.
And what is Crystal Daniels holding?
A photograph of the family.
Okay, thank you. I'll move this as the next exhibit. 13. go with two more photographs. Can you identify this, please?
That's another still photo from my body camera.
Okay, and who's in that photo?
Sergeant Daniel Baker, Crystal Daniels, and their other son coming from in the house.
Is that their 8-year-old son, Alex?
Yes, I believe it was.
All right. And he appears to have been exiting the house and coming towards you?
Yes.
Okay, I'll move that as the next exhibit.
14.
And one more photograph. That's a still shot of your body cam,
That's correct.
right? Who's in that?
That would be the other son, I believe Alex was his name.
Okay.
And Joseph Daniels.
Thank you. And I'll move that as exhibit, the next exhibit, 15.
15.
Yes. All right. Deputy Dearman, you've identified the 4 officers that were there. We've talked about your exterior video, your interior video. After you did the walkthroughs, what did you do after that?
After we did the walkthrough, I broke away from the home and began searching. And we really started breaking out. People started flooding in to help us with the search, and we just started searching from the home out.
You were literally either the first or second on scene, is that correct?
That's correct. Myself and Daniel Baker were the first 2 on scene.
And shortly after that, did the area fill up with searchers?
Absolutely.
Okay. At some point, were you redirected to a pond?
Yes.
And why were you redirected to a pond?
Some of the assets that were brought in were some canines that tracked a track from the home to a pond behind the house.
Okay. And did you go to that pond?
I did.
And can you identify this photograph?
It's a picture of the pond that was being pumped out that the dogs tracked to.
Can you hold that up for the jury? And they'll get a chance to see it, and we can't display it on the screen right now, but what is that in the middle of the pond?
That is the pump system that they were using to pump the water out.
Okay. And were you standing there as the water was being pumped out?
Yes,
Did you expect to find something?
absolutely.
Why?
Because we had 2 dogs that separately tracked to that pond.
Okay.
And both of those dogs were trained to track for a human.
Okay. I'll make that the next exhibit, please.
16.
If I could have 1 second, Your Honor. Who was the supervising shift sergeant at the time?
Sergeant Daniel Baker.
Yeah, and how long did he stay on the ground with you there?
Roughly an hour.
And what happened after that?
He entered the Tennessee Highway Patrol's helicopter with the pilot and flew with him.
Okay. Did you see the helicopter land?
I did.
Where did it land?
In the northeast part of the property from the home.
Okay. Thank you. I'll pass the witness.
Taylor? Any reason to keep the lights dim?
Well, I was gonna see if we could have Exhibit 12 pulled back up.
Pull back exhibit 12, if you will.
That was the photograph of him entering the house.
That's exhibit 12.
Mr. Dearman,
Yes.
you said this is a coffee table,
Yes.
and what's on that coffee table?
I don't recall what's on it.
Okay, so it looks like there's clothing on that coffee table, is that right?
Again, I don't know what's on it.
You didn't examine the coffee table?
I did, but I don't recall what was on it.
From this photograph, does it look like those are that's piles of clothing on the coffee table?
I can't say what it is, whether it is or it isn't. I don't know. It's not a clear enough photo.
And you were present, you said when there was a K-9 unit that was attempting to track Joe Clyde, is that right?
That's correct.
And did you see, or you saw those K-9 handlers start that process, didn't you?
Yes.
And they started that process at the house, didn't they?
Yes.
And they were located toward the front door of the house, is that right?
What do you mean they were located? Where they started their track?
Where they started it.
No, sir. I believe they both started their track from the back porch.
From the back of the house.
Yes,
Then they went around and they went by the maroon vehicle, correct?
I'm not 100% what their exact track was, but I know they left from the back porch area and then they tracked toward that pond. I didn't go with them.
You didn't go with them?
No, sir.
When they tracked it, but they were around the house, the K-9 unit?
Yes.
And the maroon vehicle was sitting there close to the house, as you explained?
Yes.
And the dogs were around that vehicle, weren't they?
Yes.
And they didn't hit on anything else there around the house?
Not that I know of. I'm not a handler, so I don't know what their indications are as hitting.
But from what you could tell, the handlers who were dealing with the dogs,
yes,
they followed the dogs where the dogs took them out to the pond, correct?
That's correct.
They didn't take them over to that maroon car, did they?
I don't recall if they did or not. I would assume that they went through the whole backyard, but I don't know.
That's all I have.
Redirect.
Deputy, just to be clear, how long was it before the K-9 units first arrived that you observed?
I'm not 100% sure. I would say roughly an hour if I had to guess. I'd have to look at the CAD card to know exactly.
Okay, thank you. No further questions.
Any reports? Thank you, Deputy. You may step down. Are we releasing him from his subpoena? You are free to go about your business. Not yours? Somebody's sunglasses are laying, I think it may be one of our bailiffs. All right, call your next witness.
Take off Derek Smith.
Step right around here, Deputy, and raise your right hand, please.
Do you solemnly swear affirm the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Good evening. Would you state your full name for the court, please?
FTO Derek Ray Smith, Dixon County Sheriff's
Can you
Office.
spell your first and last name, please?
DEREK, last name SMITH.
And Deputy Smith, you are employed with the Dixon County Sheriff's Office?
Yes, sir.
How long have you been employed there?
Since March 10th, 2011.
And what does FTO mean?
Field Training Officer.
Were you working for Dixon County April the 4th of 2018?
Yes, sir.
And did you respond to a call on Garner Street?
I did.
You remember approximately what time you were dispatched and approximately what time you arrived?
Call came out at 6:23 a.m.
Okay. And at the time, were you car 549?
Yes, sir.
Thank you. And do you know what time you arrived on scene?
I do not recall that time.
Does 6:42 a.m. sound about right? And we can refer to the CAD report if we need to.
Right. That sounds about right.
All right. And just to be definite, I would like to see Exhibit 2 for the CAD report. All right, Deputy Smith, I'm going to refer your attention to the CAD report and looking at Unit 549 DCSO. What time does it have you arriving?
06:42 hours and 59 seconds.
And Deputy, what did you do when you arrived?
Myself and Deputy Bledsoe arrived on scene at the same time. He parked in the driveway that belongs to, I believe his last name is Mr. Ledford.
Okay.
Or Langford. And I parked on the roadway and left my blue lights on. At that time, I started walking towards the residence, and Sergeant Daniel Baker asked me to start doing the missing child report.
Thank you. So one of your first assignments was to complete the missing child report?
Yes, sir.
And did you do so?
Yes, sir.
And you did that through Miss Crystal Daniels?
I did.
And did you observe the defendant, Joseph Daniels, at the scene?
He was there, yes, sir.
And how long was he there?
Very few minutes.
Okay. Where did he go?
I honestly don't know.
Okay. Did he get into his car?
He did. A red Chevy four-door car. I don't know the make.
So you're trying to complete the lost persons questionnaire. And
Yes, sir.
The defendant gets in his car.
Yes, sir.
And leaves?
Yes, sir.
Does he drive off the property?
Yes, sir.
And can we see this in your body cam?
Yes, sir.
All right, let's watch your body cam video. Deputy, do we see the red Impala?
Yes, sir.
Deputy, looking back, is this your vehicle with the flashing lights?
Yes, sir, it is.
You and another patrol car are actually blocking
That's-
the driveway of the next door neighbor?
Yes, sir. That's Deputy Bledsoe's patrol car.
Deputy, for clarification, the date and time on your body cam are incorrect.
Yes, sir.
Okay. Deputy, are you walking up the driveway of the next door neighbor, Mr. Ledford?
Yes, sir, I am.
A vehicle parked in his driveway?
Yes, sir.
With your car and Deputy Bledsoe's vehicle parked in the driveway also?
Yes, sir.
Okay. Deputy, why did you retrieve your laptop?
That is how we do our missing children reports, and that was to start the program, WinSoms at the time, so that I could start getting all the information. And I had another officer at the sheriff's office waiting for me to finish so he could print the report and send it to
Okay.
dispatch for the TBI missing child.
And that's how information about missing children is uploaded and dispersed statewide?
Yes, sir.
And you get the laptop out of your vehicle that's parked on the road here?
Yes, sir.
And are you going to walk back to the Daniels residence?
Yes, sir.
And you'll be walking again back down the driveway of Mr. Ledford?
Yes, sir.
All right. All right, Deputy, I'm going to pause it right there.
Okay.
And I'm going to ask Mr. Etheridge to fast forward to 12:10:10. If he can do that. No, and just keep letting it play. While it's playing, are you setting up on the hood of your patrol vehicle?
No, that is Sergeant Baker's patrol unit.
Okay. And is Miss Daniels standing there next to you?
While I was walking back, I called for her to come speak with me, and her and Mr. Daniels, I believe, showed up at that time to give me the information.
Okay. And are there any K-9 units deployed right now at this time while you're standing there?
I don't know if I've already talked to 579, which is our K-9 unit, or
Right.
not. I know somewhere in this time period is when he went in service, and I had asked him to call me so I could give him a better location.
So we'll be able to confirm that from the CAD report,
Yes, sir.
whether that unit, the K-9 unit, shows up before or after you?
Yes, sir.
All right. You don't remember seeing any K-9s?
No, sir. There was no K-9 unit.
No K-9s while this is going on?
No, sir. No.
All right. And we're going to be watching for, you've testified that Mr. Daniels, the defendant, leaves.
Yes, sir.
And do you know at what point on your video that he leaves?
It's here in just a minute.
Okay. And where do we need to be looking on the video to see his car leave?
It's pretty much through Sergeant Baker's car. I believe you can see brake lights and a little glimpse of the car on the right-hand side of the TV.
Okay. And from your personal memory and observations, you're sure that the defendant left?
Yes, sir.
You watched him get in his car and leave?
Yes, sir.
Okay. All right, Deputy Smith, as we're approaching the mark, I want to draw your attention to 12 hours, 10 minutes, 07 seconds, and describe what you see on the bottom right-hand corner of the screen at that time mark.
I see his vehicle backing out,
Okay.
and he turns back behind Sergeant Baker's car. And all you can see is just a small glimpse of it.
That's his vehicle leaving right there.
Yes, sir.
All right, thank you very much. You can stop that. Now we'll move a copy of this body cam video as the next exhibit.
Yes, sir.
And I'm also going to move a clip of just the car leaving the driveway as Exhibit 18. Next photo. All right, Deputy, after watching your video, we've taken some still shots, and can you identify this photo?
That's the driveway of Mr. Ledford.
Okay. And is this a hard copy of what we're seeing on the screen?
Yes, sir.
And you're walking down the driveway of Mr. Ledford?
Yes, sir.
Towards the Daniel residence?
Yes, sir.
We'll move that as Exhibit 19. And from your body cam, you took another still image. Can you identify this?
Yes, sir.
What is that?
That is this photo, and that's from my body camera footage, and that's going to be Mr. Ledford's vehicle
Okay.
in that driveway.
I'll move that as the next exhibit. Yep. And Deputy, can you still see the red Impala in the background, bottom right corner of this photo?
I can.
And it's even harder to see in that photo, but is that what we see on the screen?
Yes, sir.
I'll move that as the next exhibit. Deputy, after you finished the lost persons questionnaire, did you stay on scene for a while?
I was on scene for several days straight.
I think in trial prep, you told me about 72 hours straight.
Yes, sir.
What were some of your assignments during that 72-hour period?
Of course, getting on scene, taking the report, missing child report, and then assisting with search efforts.
Were you ever detailed out to conduct any specific searches of residences or fields?
I was later, right after I finished with the missing child report. I went across the street and started searching, and then went north up to the residence right before Pruitt Road. Okay. And then I went across and spoke with my father, who owns the property at Garner's Creek in South 3rd, and spoke with him, and then I was given a detail to keep the news media at Pruitt and Garner's.
So let's talk a little bit about what you just said, that you spoke to your father.
Yes, sir.
Now, we've had to redact some of the audio.
Right.
Had we played it, you could be heard speaking with your father on the phone.
Yes, sir. I was speaking to my father while en route to the scene.
And he lived 2 houses down from the Daniels?
Yes, sir.
And did you grow up in that area or ever live over there?
I did.
Were you living there before all the houses were there?
Yes, sir.
Did it all used to be just a big farm area?
Yes, sir.
Did you and your father and family have a cattle farm?
Yes, we had cattle and horses.
So you're pretty familiar with that whole area?
Yes, sir.
And I think you asked your dad even to go out and search his outbuildings.
I did.
And why did you do that?
In the mornings, my dad will open his shop up before he goes out to work, and I didn't know if maybe the child had ran out and went towards my father's house and saw a tractor and wanted to climb on it.
Absolutely.
Being told that he was autistic, they're drawn to colors, from what I understand, and having a big orange tractor, I thought maybe it was, in my mind, a hope that maybe he would be there playing on the equipment.
Okay. And again, you're pretty familiar with the whole area. Did you go over to the Dodson's residence?
I did. That was the first place I went.
And was that across the street from the Daniels?
Yes, sir.
And what did you do there?
Went behind the residence, went around the whole property, and walked the fence line, and the grass was tall across the fence, and you would be able to see if somebody had walked through there.
Okay.
And I didn't see any signs of anybody walking through there.
Now, in the photographs, we showed a couple, and on your body cam, where your vehicle and Deputy Bledsoe were blocking the driveway of Mr. Ledford. Is that correct?
Yes, sir.
Now, we saw what may appear to be a little shed on his property.
Yes, sir.
That's actually what's called a tiny house. Is that correct?
Yes, sir.
And your father, did he sell that property to Mr. Ledford?
I believe so.
Okay. At one point, that was a part of your father's
Yes,
tract
sir.
of land.
Yes, sir.
All right. I'll pass the witness.
Walker?
Did you talk to any of the other neighbors in the area?
I did not.
What about over at, did you say Debbie Dotson?
I don't believe I spoke with her.
Right.
I went around her property. I believe we knocked on her door and nobody answered.
Okay. And did you go to Mr. Ledford's residence?
No, sir, we didn't.
Would it not be normal to go to houses around and talk to people to see if they saw anything?
At that time, I didn't, because we were just looking for the child.
All right.
And we have that 2-hour window from the TBI to find the child. So that's what we were trying to get into, was that 2-hour window of finding the child. So I didn't knock door to door.
And so it occurred to you that the child may have run over to your dad's place?
Possibly, yes.
Based on a tractor being over there?
Yes.
And that autistic kids are attracted to colors?
Yes.
Right. What else did you do as far as helping to search? Did you go with any canine units?
I did not.
Okay. Did you observe any canine units work in the area at any time?
I did later in the morning. A female with, I believe, EMA showed up with her dog. I don't know what kind it is.
Okay.
I know our canine officer Simmons arrived. I can't give you a definite time on that. He showed up within an hour of me being there.
And did you see what areas those dogs worked on the Daniels property?
No, sir. After I was asked to set up a spot for the news media at Pruitt and Garner's Creek, that's where I was at till, I believe, 1 o'clock in the afternoon. And then I went and relieved officers at Lane Road and South 3rd, and I helped block traffic there.
Did you inquire to see where Mr. Ledford's car had been the night before or the very early morning hours?
No, sir, I didn't.
And I assume you don't know where it had been?
No, sir.
That's all, Your Honor.
Anything further?
No, sir, no question.
Thank you, officer. You may step down. You have another short witness. We've got our jury, we're gonna have to get them fed, so do you have another short witness?
No, sir, we do not.
All right.
The next witness that is available today will be lengthy and will require a hearing outside the president.
All right, then I think we'll adjourn for the day. Ladies and gentlemen, we are going to quit for the night simply because of the fact that the next witness, I'm told, is going to be very lengthy and will require at least some sort of an out-of-jury hearing. So we're going to go ahead and allow you to step back across the way, and then we'll make arrangements to transport you for your dinner and then back to your hotel. Thank you for your cooperation. They can leave them in the jury room.
They can leave their notebooks in the jury room.
Be seated, please. You have something, Mr. Crouch?
As we were in Chattanooga selecting jury, we did receive another motion from Mr. Lockhart, a motion in limine. So our two witnesses on that were here all day. I released them because it was 5 o'clock, but they will be here first thing in the morning for the jury out hearing.
All right, can we start that at 8:30? Any reason not to do that at 8:30 so that we can have the hearing and not delay the start of the trial?
It's fine with us, Your Honor, if it's all right logistically to get my client here, I assume.
Oh, I'm sure they can get him here. So. All right, well, let's take your motion in limine up, and I'm assuming that means I have to hear from these folks before we bring the jury in some fashion, and then let us make a ruling on your motion in limine. And then we will hopefully be able to begin the trial promptly at 9. So we will stand in recess then until, or adjourn rather, until tomorrow morning at 9 o'clock.
Recording stopped.
tomorrow morning at 8:30.
All rise.